servants under sections 13(2) and 409(I)(2). The bail application was directed to be listed along with other matters in this will. It has not yet been listed. And I am not liable either under 13.
That merit.
A representation filed against the order of a single judge and the informant return with X certificate who was
Give your
certificate he has been selected, but that was challenged the single judge. But against the order, let matter.
At least there is one view against you. There is one view of this court which is against you. Where is the question of urgency?
Pardon to mention,
Another matter, my lord, a single bench matter.
One apple a day, Mr. Khan.
Since 94,
Give your slip. Give your.
since 94 to feel that
Please mention it in your memo and give, sir will consider.
All right. Give your slip.
pardon to mention, my lords, this is a PIL matter regarding the illegal sand mining, and the issue is that they
You
are.
have filed 3 mention slips. This is third.
No, my lord. Yesterday, at the time of law, your lordship were raising at that time, I mentioned at that time, the number was not allocated to her. Only diary number was there. So thereafter, I getting the number.
This illegal sand mining is going on since when?
My lord, they just started within this 20 days. They already destroyed the river bank. That village is very vulnerable to the flood, my lord. And the police is a mute spectator. And but recently, though Tahsildar intervened, but they are threatening me as I may raise the voice to kill. And then
Yes, I remember. I had read your slip.
my lord.
It is not that you had not given. Sorry. Yes, I have rejected your mentioning.
Okay, lords, my lord, Monday.
Sorry, don't do that. We will take up.
With the Lordship's permission, may I mention a fresh tender matter? Because I have been.
Please give your slip.
Please.
the lordship's permission, item 32, your lordship had asked me to remind the lordship
Well,
that college examination form fill up matter.
So could you serve a copy on?
Yes, I have served a copy. Actually, he's on his way. He said, I have informed him, I'll be mentioning at 10:30.
We will see.
I beg pardon, my line from 21.
You can ask him to seek instructions in the meanwhile.
He has short instructions.
See, according to you, you have permanent affiliation.
Yes.
And by impugned communication, you have been granted for provisional affiliation. So
My
this
lord.
is-
I intimated to him that my only concern is the 60 students may be left out. So you address that issue only for the timing, because accordingly, your lordship will adjudicate the matter. So I have, he has got the instructions. He's reaching in short time. Since your
he has
lordship
got
had
the
asked-
instructions.
Yes. That's what he informed me. I asked him whether he's going to take adjournment or, so he said, no, I have the
All right.
instructions.
My lord, item 21, my lord. Item 21, my lord. Yesterday I also mentioned, my lord, and the matter is listed today. 21,
Yesterday, what happened?
Yesterday, it was in the item 6, my lord. And today it is 21, my lord. If it will not be listed today, then my lord will be taken up today, my lord. Because the meeting is held at 4 p.m. today, my lord.
Meeting of what?
Meeting of the Panchayat office, Panchayat Samiti.
For what?
That is, there is direction of the single judge, my lord. It is the contribution of the section 4 of the Gram Panchayat Act, my lord.
This is writ appeal.
Yes, my lord.
Appeal is not.
Mr. Naik, how many previous writ applications have been filed regarding that?
There are 6.
Yes.
So there the litigation is going on, my lord.
Sorry.
Pardon, my lord. My lord, it's a press contempt, my lord.
Fine.
Yes,
May I pardon, my lord, that item 43 of the today's list, my lord. Yeah. Tender matter, during pendency of the writ petition, they have floated another tender for the self-same work. Today may not, which may pay it for Monday, my lord.
Pardon to mention, my lord. My
Obliged.
lord, CMPL number 422 of 2022.
Why don't you give your slip?
Sorry, my
This
lord.
is restoration.
Yes, my lord.
Just give your slip. That will be listed.
Obliged, my lord.
And not mentioned in the economics today, because that's the concept, building house is going to be started. They've already started.
All right, that will be demolished. You don't want the building to be there.
No, we don't want to be building on that plot. On which plot we have?
So that building will be demolished and subsequently a new building will be constructed at the site if your case is finally decided in your favor.
Taken up together.
Yes.
That's a kind permission. Item number 44. It is not likely to be today. there are 4 writ appeal, one by UPSC, others by the selected candidate, and my learned fellow is also fine. So call it next week, any day, so that at least can be taken up. That will be convenient for me.
Any day at 2 p.m.
Yes, that will be fine. That is okay. Obviously.
40. First. 41st. To be mentioned, item number 1.
The action of the opposite
No,
party.
what happened in this case
My
that during the course of correction of the order, we noticed that some relevant aspects have been ignored. They were relevant and maybe in your favor also. So, and therefore we did not upload that order. We want to rehear
Yes,
all the matters.
yes.
Because there is only one issue involved, whether you are entitled to that
Right.
difference of arrears of salary on the ground of parity. So somehow we had missed at the dictating the order. So we will, and we have also noticed that counter affidavits were not filed.
Yes, my lord, they have filed the counter.
Not in all, not in all.
Not in all the cases.
They have
So
to
we will-
adopt.
We will take up the matter on, say, after 2 weeks. In the meanwhile, in such cases where counter affidavits have not been filed, they file it and then we will see.
File or examine if you want to
Because-
adopt.
And some matters were remanded.
Remanded in the sense disposed of. Similar matters which had been directed to be tagged with these matters, they have been in the meanwhile been disposed of by the learned single judge.
Yes.
Saying that the government will decide your
They
representation.
will approach the government.
Approach. So find out if anything has happened, then if it will
Yes.
go in your favor or
Yes,
anything,
ma'am.
that might help you.
Yes, ma'am.
That you get instructions also.
Yes, ma'am.
Similar matters,
Yes, ma'am.
representations had been directed to be disposed of what has happened. So while filing counters,
These things happen when we go by perception.
Please.
It will come under the same heading, is this matter, these matters under the same heading on 2 weeks. Uh, While correcting the orders passed in these cases, disposing of the orders whereby these applications were sought to be dismissed, it has, on perusal of records, it has been noticed that certain aspects had missed the attention of this court. Stop. The court intends to rehear the matter afresh. Stop. List this matter of these cases on 2 weeks. We will take up the on Thursday. Same day, 21st. Thursday, 21st. Same heading. 28th. 28th.
please see
28th.
that you.
It's a very simple issue. The simple issue, they claim that they are non-teaching employees working in unaided institutions. Aided institutions. And they are entitled to the same benefits which the government employees are entitled to in accordance with the provisions under the Education Act.
Rule 9 of that 74.
Under the rules. The definition of educational institution finds place in the Education Act, and these institutions come within the definition of the Act. So since you have paid actually the amount for that period to the to other employees, so they being staff, some of most of them are non-teaching.
Teaching, not teaching, both. Both.
Non-teaching. So they are claiming. No, in case of teachers, there is some order in their favor.
No order. That will be notionally, that will be there.
No.
They've said. For payment, there is no order.
Yes.
Matters for orders. Matters under the heading for orders, item number 36. Item 36.
Disposed of matter in that an IA has been filed. Yes. None appears for the petitioner when the matter is called. This application had been disposed of on 10/5/2000, directing yes. This application has been disposed of on 10/5/2000. This missed case for modification of order has been filed in the year 2000 and has not been listed. This application is not maintainable. Nice. There is no appearance on behalf of the petitioner. In the meanwhile, 24 years have elapsed. We are not inclined to entertain this application, which is otherwise not maintainable. The application is accordingly dismissed.
Item 37.
None appeals for the petitioner when the matter is called. This appeal is barred by 30 days, but steps for limitation has not been taken. 1 week time is granted for taking steps for limitation, failing which this appeal shall be dismissed without further reference to the bench.
38.
For limitation shall be taken within 1 week, and defect pointed out by the stamp reporter shall also be removed in the meanwhile.
38.
38 on behalf of Budhiram Das next week. On behalf of Budhiram Das next week, my lord. 38.
Paying for time.
No, what do we do?
Delays 55 days.
Then,
Is notice required to be issued because I think respondent 5 to 8 are your own supporting.
on behalf of Budhiram Das, on behalf of Budhiram Das next week.
ठीक है. आपन का नाटा कौन?
Sunil Kumar Patnaik.
Mr. S.K. Patnaik prays for an adjournment on behalf of Mr. Budhiram Das, Garnet Counsel for the appellant. List the case on 21/11/2024.
39.
Lordship, in this matter, there is a defect, your lordship. Due to non-filing of certified copy, the SR could not be made. Lordship, 3 weeks time may be given for removal of defects. In the meanwhile.
Why should we grant time? If you want to remove the defects, you remove, otherwise the application appeal will be dismissed.
Your lordship, in the meantime, I will remove the defect, your lordship.
Mr. What is your name, please?
Avinash Swain.
So,
A. Swain.
Avinash Swain, Garnet Counsel, prays for an adjournment to file the certified copy of the order. To file the certified copy of the order. This is the case on 21/11/2024.
Oblige, your lordship.
Item 40.
By item 40 on behalf of Mr. Palit, my lord,
Similar matter was before this honorable court on 5th, my lord, that has posted, that will be posted on 12th, my lord, Tuesday, my lord. So I pray this matter may can
But
be
in
taken.
this matter, notice has not been issued.
Notice, my lord, has issued.
In this notice has been issued.
My lord,
Do you have the file? Do you have the file?
my lord,
Please check.
my lord, in 19 days delay, my lord.
When, on which date was the notice issued?
Order has not, I have no order, my lord.
Do you have the file?
Yes, my lord.
Okay, which date?
My lord, it has not, I have no order, my lord.
So if you don't have any order, how was the notice issued? Notice issued, I could not
No,
find.
notice has not been received.
My lord, 19 days delay, my lord.
Yes,
I pray
but
notice,
you're saying a similar matter is listed on 12th.
on 12th,
12,
similar
11.
matter. So notice in
Please
this
give the
matter,
number, please give the number.
WA 250 of 2024,
25.
0 of 2024. Manoj Kumar Behra,
This the case, you are Mr.
Amita Mishra.
Mr. Amitabh Mishra, learned counsel for the appellant submits that, is it the same common order or different orders?
Here also 19 days delay, the same.
Are you able to hear or not?
Yes, my lord.
Yes, it's the same.
Same order, my lord. On the order was passed on 12th 11 2022, my lord.
12/11, there is no order on 12/11.
Sorry, my lord.
Yes, list the case on 12/11/2024, when it is stated that connected writ appeal number 250 of 2024 is posted. Is it the date?
My lord, honest your truth.
Just one moment, please. All right. Certified copy. Have you filed the certified copy?
No, my lord.
Mr.
We have filed IA for the
that,
dispensing of.
appearing on behalf of the appellant undertakes to file the certified copy within 2 weeks.
My lord.
Concerning the said submission, the IA is disposed of. The certified copy shall be filed within a period of 2 weeks.
My lord.
Mr. Palit is not aware of when the case is posted. What is the
Tuesday. Mr. Rautrai mentioned that matter.
yes.
30.
19 days delay.
This is also 19 days delay. The other one where Mr. Rautrai was mentioning 37. Your lordship went up to 36 the other day. 37th matter.
Here
just
notice has not been issued. That is what we are asking. That he is not aware of.
sorry, my lord, sorry.
Yes.
List with the connected matter on 250.
Tuesday, my lord.
You file with that date, but wherever it is posted.
No.
This with the connected matter, WA number 250 of 2024.
I'm sorry.
250, please say the correct number.
My lord, 250.
No date, whenever it is.
Item 41.
But you file the certified copy within 2 weeks.
My lord.
That IA we have disposed of.
My lord.
Item 41, may I please, my lords. In item 41, we have not filed the certified copy. I pray your lordship may grant me some time. I have already asked my officers.
Copy
They
of
will
the IA.
Huh?
Survey copy limitation.
Yes, yes. The limitation has also come. Limitation, we have, it has been, there has been a delay of 213 days.
Yes.
186 days.
Oh, sorry.
The
Yes, yes. Yeah.
limitation has come, he has also come. Mr. Mahanti has also come, so.
Survey copy.
Yes, in course of the day, I am serving a copy.
Sir, Bibisar Das, additional government advocate, undertakes to file the certified copy of the impugned order within a period of 2 weeks. 2 weeks, considering the said submission, the IA is disposed of, granting 2 weeks time to file the certified copy. Full stop. IA 3019 of 2024 for condemnation of delay. Since Mr. Lakshmikant Mahanti, learned counsel, has appeared on behalf of respondent, sole respondent? The sole respondent.
There are.
On behalf of respondent number,
Respondents.
the contesting respondent number 1, copy of the IA be served on him by tomorrow. List the case on today 21/11/2024. Objection, if any, shall be filed in the meanwhile.
My- Order short over. Mention matter, item 32.
It's small. If I, since being I'm officer of the court, it's my duty to point out my small inadvertence. Yesterday, thinking that yesterday was 7th, and submitted before day after tomorrow. Exam form fill up as day after tomorrow. So in fact, that your lordship, according to my submission, has reflected 8th. That is actually 9th, Saturday.
I was wondering whether it is today. Okay.
I thought that I'm on 7th.
So this is-
My lords, so far as my learned seniors contention is with regard to permanent affiliation and affiliation is concerned, we have objection to that because they had 240 seats and subsequently after the formation of the university, it has been reduced to 180, which is a subject matter of adjudication while file a counter to that effect, my lords. So far as his interim prayer is concerned, my lords, I have taken instruction. Rightly or wrongly, they have taken admission of 60 more students, considering the fact that this honorable court, before the formation of university, has allowed 240. So, lordship may kindly, may consider considering the career of these students, subject to, if a lordship so permits, subject to the outcome of the writ petition, and they may file an undertaking because if the governing body has come, that from the next year they will not.
No. That since he has already submitted that subject matter of adjudication. In fact, my case before your lordship is total violation of principle of natural justice, no notice given, nothing. After the advertisement was issued in May, they are coming, they are staying there. What their submission is, they have conducted an inspection thereafter. That is absolutely untenable because as per the provisions of the Odisha State Universities Act, they are supposed to carry out a procedure for my
No, that aspect we will consider later.
Yes.
Once
That is
the
what
file counter affidavit, we will examine.
Yes.
Now, at present, the question is that you have admitted 240 students.
Yes.
60 excess. 60 excess.
Yes.
No, 240 students when?
By
By
29/8.
29/8.
August.
Yes, 29/8, 24. And when this communication was sent?
This was sent on 21/9.
21/9. Before this 21/9, there was no communication.
No communication. That is my case, my lord.
I have one submission. So, your lordship, on 12/8/2024, the governing body has filed an application for affiliation with effect for the academic session 22-23. So, my lords, admittedly, it is from their own record, it is found. We took the instruction, we have the record, which I'll file. On 12/8/24, they filed an application for affiliation of 22-23. So, my lords, right now, we don't want to get into that.
Yes.
Only thing is that as my learned seniors contention for the 60 students, my lordship may allow them for the appearance, but only difficulty is, my lord, it will open a floodgate to other colleges. If a lordship remembers in another case, lordship are directed for an inspection by the government. So therefore, they may be admitted to, they may be allowed to appear the
Which item
examination.
is this? 32.
So, my lord,
I'll make a
only
fair
thing that
submission. I'll make a fair submission as my learned friend is saying. This year they have done it, my submission, that which will be adjudicated. Whatever inspection, whatever proceeding they want to initiate, they should put us to notice. Thereafter, do whatever they want for the next session.
No, for the present, we are concerned with this admission
Yes.
this year only.
Yes.
So we shall decide on the basis of whatever for the subsequent academic sessions.
Yeah, they can.
Subsequent academic session, you have already put to notice because of this.
Well, it's 2024-25.
Yes, so this you are contesting. What they are saying subsequently, let them not do. So you already put
yes,
to notice.
that would be the fairest thing, my lord.
Fairest means how can they
How
do
can-
it when you've stopped them this year? They cannot do it.
My lord, so once your lordship directs it, but because of the previous order of your lordship,
There are two aspects.
Yes.
We are not disposing of the
Yes.
writ petition. We are just passing an interim order for you not to insist upon that the number.
sorry,
240 students shall be allowed to pursue their studies in the meanwhile, subject to final adjudication.
Your
All
Lord.
right. And for the subsequent academic session, we'll for this academic. This is only oral submission. We cannot decide this for. The petitioner is governing body of Gangadhar Mohapatra College, Puri.
Law College.
Law College.
Law College, Puri. So it is the petitioner's case that a permanent affiliation was granted to the college with strength of 240 students in LLB course.
In pursuance to this honorable court's direction by
Under-
Annex 6.
Under which provision? Clear provision, no?
My lords.
Provision or direction of this court?
Direction
No,
of this-
there was a permanent recognition of 320 seats initially. Thereafter, the matter came up before this honorable court. This honorable court by Annexure 6 this directed that they had the infrastructure to accommodate 240 students.
Which date?
My lords, date is 5/1/2006 passed in.
Sir, therefore, we want to know that affiliation was granted under the previous, the University Act, Odisha
University Act.
University Act. This is what we want to record.
Yes, and subsequently the state government has clarified.
Submit that the college was imparting before with 240 students based on permanent affiliation granted by which university?
Utkal University.
Utkal University under the provisions of
Odisha University's first statute.
Odisha University's Act.
Statute.
First
First statute,
First statute.
Odisha University First Statute.
1990.
Stop. Subsequent to enactment of Odisha Technical University.
Madhusudan Law University.
Subsequent to the coming into effect of the
No,
Madhusudan
that
law.
must be by an act, enactment. The university must have been established by an act.
But it is under the Odisha Universities Act
Act.
only, but new university are there. So far as not.
There, that is under
The
Annexure 8.
notification.
Subsequently, Madhusudan Law University was established. And this college affiliated to said Madhusudan Law University. Stopped. The college has admitted 240 students for the academic session 2024-25. By 29/8/2024, which was the last date for admission.
Yes,
Which was the last date for admission. No stop. Subsequent to much after 29/8/2024, the Gopbandhu so-and-so University has made a communication to the college to letter dated 21/9/2024 regarding grant of provisional affiliation with 180 students only. Stop. Next, Land Council appearing on behalf of the petitioner has submitted that the university could not have issued such communication restricting the strength of the students for academic session 2024-25 to 180 only, particularly in the light of this court's order dated
5/1/2006.
5/1.
2006 passed in WPC 13527 of 2020, 2004 under Annex 6.
Let a counter affidavit be filed on behalf of the university. What was the party number?
It's 1 to 4. 1 to 4.
List this case on 4 weeks. Stop. It is directed that in the meanwhile, the opposite parties shall not insist upon the said communication dated 21/9/2024 to the extent the same relates to restricting admission. Relates to strength of the students to 180 only.
May I submit? If you Lordship kindly observe that because it is a two different persons affecting. One is the juristic person, the governing body, and the students, my lord. So far as students are concerned, my instruction is we have no objection. Lordship may kindly observe that the governing body itself has filed an application on 12/8/20.
Mr. Counsel, you file your affidavit.
So far as the examination is concerned, my lord, so they may give that undertaking at least, my lord.
Who?
The students, because my petition.
What student? They are there before, we can dismiss.
Yes.
What
Yes,
undertaking? Exams are not now. They have recently been
Yes.
admitted.
all right.
Lordship may say 12 and 14.
Any
14
difficult-
also, Annex 14 also they have, Annex 14 also they have insisted on that 180. 12 and 14.
Therefore, the interim order is only to that effect, that you
I'm
shall
obliged.
not insist on this. That's all. And then we will decide finally.
Yes.
Annex
Yes,
12 and 14.
2 weeks. Yes.
Deeply obliged, ma'am.
Is there any urgent matter
Fresh admission, any urgent?
should be taken? Because we are going to take up one matter which is fixed at 11. All right.
Item number 2.
Yes. Where is at serial number?
3 and 5.
I don't know.
I will come back after.
We will inform you.
No, my associate is there. I was just, since your lordship said that this matter will be taken up, I was just.
Ask your junior to sit.
My associate is there, my duty.
All right.
I was just
All right.
trying to find out whether this matter itself will consume the entire day.
Is it
That-
possible to predict?
Matter that only your lordship can have.
Very difficult to predict whether. Yes.
Item 2.
Yes,
Please. Will you recollect when I
yes.
concluded yesterday, I was on Silipi, that's a 2020, volume 16, SCC 489.
Can question? Very good. Thank you.
Yes,
Where I was referring to para 12, where reference has been made to BNS Joshi's case, where the price is not the one of the criteria or it's the criteria at all. Then para 15 and all, they refer to AFCONs, which has been cited earlier. Then the two interpretations in para 20 that has been quoted. Now kindly go to para 23.
yes.
We then come to the moot question as to whether the petitioner, firm and the company are. It's at page number 502. I am referring to para 23.
Yes.
Come to the moot question as to whether the petitioner forms related forms within the meaning of so and so. That is one of the issues they were considering with regard to that. Then kindly go to para 25. Next page. That brings us to the most contentious issue as to whether the learned single judge of the High Court was right in holding that the appellant orders were bad since they were without reasons. We must remember that we are dealing with purely administrative decisions. These are in the realm of contract. While rejecting the tender, the person or authority inviting the tenders is not required to give reasons, even it be a state within the meaning of Article 12 of the Constitution. While rejecting the tenders, these are all commercial matters. Absolutely, there is no requirement at all to give any kind of reasons.
Yes.
Then further, these decisions are neither judicial nor quasi-judicial. If reasons are to be given at every stage, then commercial activities of the state would come to a grinding halt. The state must be given sufficient leeway in this regard. Response 1 and 2 were entitled to give reasons in their counter to the writ petition, which they have done.
Yes.
Then, so in the instant case, the rejection order I pointed out, categorically they refer to some of the clauses. Even independent of that, even there are no reasons, nothing has been said also. The rejection will not vitiate provided something is shown with regard to the, that is the law on the point. Now the next would be 2021, volume 16, SCC 808. There's a Galaxy Transport by 3 judges.
2021 volume.
2021, volume 16, SCC 808.
Yeah.
Para 14. At the bottom, at the page number 815. In a series of judgments, this court has held that authority that authors the tender document is the best person to understand and appreciate its requirement, and thus its interpretation should not be a second guessed by a court in judicial review proceedings. Then they refer to AFCONs, which I have already cited. In the next para 15 of the AFCONs is quoted. Then in para 15 of that judgment, they refer to Bharat Coking Coal case. Kindly noted para 50 of that Bharat Coking Coal case, which is referred in that particular para. Lastly, we deem it necessary to deal with another fundamental problem. It is obvious that respondent number 1 seeks only to enforce terms of NIT. Inherent in such exercise is interpretation of contractual terms. However, it must be noted that judicial interpretation of contracts in the sphere of commerce stands on a distinct footing than while interpreting statutes. We are not interpreting statutes here to say that this is correct or this is not correct. Then further, para 51, In the present case, it is clear that BCCL and C1 have laid recourse to clauses of NIT, whether it to be justify condonation of delay or respond number 6 in submitting performance bank guarantee or the addition to resume auction on grounds of technical failure. BCC having authored these documents is a better place to appreciate their requirements and interpret them. Then para 52, the High Court ought to have deferred to this understanding unless it was patently perverse, which was my argument at the beginning. Patent perversity. So this is the one. Rest of the paras may not be required. This is then the most recent is 2022, Volume 5, SCC 362. There's Agmatel Private Limited.
Yes.
Kindly turn to para 24. At page number 379. The scope of judicial review in contractual matters and particularly in relation to the process of interpretation of tender document has been subject matter of discussion in various editions of this court. We need not multiply the authors so and so refer. In Galaxy Transport, Afghans, which again that's they have quoted, has also been considered. This court has disapproved the interference by the High Court in the interpretation of the tender innovating authority of the eligibility term relating to the category of vehicles required to be held by the bidders in the tender floated for supply of so and so. Then they refer to Galaxy. Para 14 and 15. In para 15 of that Galaxy, the letters, the words mentioned in bold, it is possible that the owner or employer of a project may give an interpretation to the tender document that is not acceptable to the constitutional courts, but that itself may not be reason to interfere with the interpretation of so and so. Madam, got it? Para 25.
Yes.
Yes. They refer to Galaxy, which I just now cited.
Yes.
There the sub-para is para 15. Just below that, the words highlighted.
Yes.
Then in para 16, reaffirm the Silipi, which I cited earlier. Then finally, at para 26, the above mentioned statements of law make it amply clear that the author of the tender document is taken to be the best person to understand and appreciate the requirements, and if its interpretation manifestly in consonance with the language of the tender document or subserving the purchase of the tender, the court would be preferred to keep restraint. Further to that, the technical evaluation or comparison by the court is impermissible, and even if the interpretation given to the tender document by the person in offer is not such acceptable to the constitutional court, that by itself so and so. This is a consistent view taken by the courts by following one after the other judgments. Then one aspect very old judge, this one judgment 2000, volume 2, SCC 617. That's a Air India case.
617.
Yes, 617. 2000, volume 2, SCC 617.
Yes.
Kindly go to para 7.
Yes.
Yes. The law relating to award of contract by the state, its corporations and bodies acting instrumentalities and agencies of the government has been settled by the decisions of this court in Raman Dayaram Shetty so and so case. So many cases are quoted. The award of a contract wherein it is by a private party or by a public body or the state is essentially a commercial transaction. In arriving at a commercial decision, considerations which are paramount are commercial considerations. The state can choose its own method to arrive at a decision. It can fix its own terms of invitation to tender, and that is not open to judicial scrutiny. It can enter into negotiations before finally deciding to accept one of the offers made to it. Price need not always be the sole criterion for awarding a contract. It is free to grant any relaxation for bona fide reasons if the tender conditions permit such relaxation. It may not accept the offer even though it happens to be the highest or the lowest. But the state, its corporation instrumentalities and agencies are bound to adhere to the norms, standards and procedures laid down by them and cannot depart from them arbitrarily. What you have done, we have interpreted the particular norms and which has been set out for all the purpose, and we have acted strictly in accordance with them. And any other interpretation which one of the unsuccessful bidder is projecting, that may amount to deviation even from the norms which is set out, even it is not permissible. Number two, the price also cannot be a factor. Again, it is said there, and by referring to even to Jagdish Mandal's case in the then also Silpi also, which I have cited, and BS and Joshi. In all three cases, consistently it has been, price alone cannot be the criteria. Price is not the criteria at all to decide whether it's a public interest or overwhelming public interest or not. Considerations are totally different. Norms are to be followed. That is the requirement. Then at the cost of repetition, although in all these judgments they have said about Jagdish Mandal's case, just 2-3 sentences I would like to read from 2007, volume 14, FCC 517, that is Jagdish Mandal's case.
Yeah.
May I request to go to para 21.3. The reference has been made to Runak International Limited case.
Yes.
Whereunder kindly turn to right side para.
Yes.
Para 11 of that Runak International case is referred to. After about 5 lines. At page number 5 to 9,
Yes.
at the bottom. A mere difference in the prices offered by the two tenders may or may not be decisive in deciding whether any public interest is involved in intervening in such commercial transactions. It is important to bear in mind that the court intervention, the proposed project may be considerably delayed, thus escalating the cost far more than any saving, which the court ultimately affect the public money by deciding the dispute in favor of one tenderer or the other tenderer. Therefore, unless the court is satisfied that there is a substantial amount of public interest or the transaction is entered into mala fide, the court should not intervene under Article 226 in a dispute between two rival tenderers. Then kindly go to para 22. On the right hand side, judicial review, the sentence starts from
Yes.
with the judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, or so and so. Its purpose is to check whether choice or decision is made lawfully and not to check whether choice or decision is sound. When the power of judicial review is invoked in the matters relating to tenders or award of contracts, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contracts are essentially commercial functions. Principles of equity and natural justice stay at a distance. If the decision relating to award of contract is bona fide and is in public interest, courts will not, in exercise of judicial review, interfere even if a procedural aberration or error in assessment or prejudice to a tenderer is made out. The power of judicial review will not be permitted to be invoked to protect private interest at the cost of public interest or to decide contractual disputes. The tenderer or a contractor with a grievance can always seek damages in civil court. Next 4 lines, important. Attempts by unsuccessful tenderers with imaginary grievances, wounded pride, and business rivalry to make mountains out of molehills of some technical or procedural violation or some prejudice to self and persuade courts to interfere by exercising power of judicial review should be resisted. Such interference, either interim or final, may hold up public works for years and delay so and so, so and so. Therefore, the court before so and so, these are the events. This is the Jagdish Mandal's case, which has been followed in pattern of decision as a basis. Now, these are the judgments which I would like to place before the sample court. Now, one aspect which the other side cited the recent judgment of the Honorable Supreme Court in Banshidhar Construction Company, authored by Justice Bela Trivedi, to say that the court can interfere even if when it is shown to be arbitrary.
Yes.
Yes. Number one, the facts are totally different. Number two, case has been decided on facts of the said case. Number three, particular observation in para 16 that favors our case.
Yes.
Kindly go to para 16, where before coming to the conclusion in a particular case,
Yes.
the basis was admittedly respondent number 8 had not submitted the second scanned copies of its audited annual reports for last 3 financial years at the time of submitting uploading of the bid documents before the last date so and so, and the same were submitted on only when the clarification was sought from the respondent after the technical bids were opened on 4/12/23. This is the 14. Then, based upon that, para 20, thus, the said action of the respondent in rejecting the technical bid of the applicant on absolutely extraneous ground and accepting the technical bid of the respondent number 8, those submitted in utter non-compliance of the mandatory requirement of clause 10 of NIT, and subsequently calling upon the respondent number 2 furnish the shortfall of documents after the opening of technical bids, was totally arbitrary and illegal. There cannot be any disagreement to the legal proposition proposed in Ketana addition that this court relied upon the learned counsel for the response to the effect that court does not sit in court as appeal in the matter of award of contracts and merely reviews the manner in which addition is made and the government takes so and so. So the issue was altogether different when some relaxation was given to the third party, respondent number 8, who was allowed to submit the contract. That same treatment was given. That was on facts in a particular case, and no law has been laid on this particular judgment apart from that, saying that in the arbitrary exercise of power, that's all. Whereas the further in para 14, it has been observed that you are required to adhere to the norms. There was a deviation from the norms. Therefore, the court said, yes, there cannot be any deviation from the norms. Therefore, you should have treated in conformity with the norms with
No,
both.
they must be relying on the second part of paragraph 21.
Yes, I'm ready. Yes, that's all. Paragraph 21. Yes. However, it is equally well settled that decision of the government decision must be free from arbitrariness and must not be affected by any bias or actuated malafide. Government bodies being public authorities are expected to uphold fairness, equality, and public interest even while dealing with the contractual matter. Right to equality under Article 14 abhors arbitrariness. Public authorities have to ensure that no bias, favoritism, so and so during the bidding process, and the entire bidding process is carried out in absolute transparency.
So these are well accepted exceptions.
Well accepted from Ketana, right from Raman Dayaram Shetty's case 1976, even till now the law did not change. Law, it holds good and nobody can change it. This is the law. But here on facts, they have said on a particular situation, they said they interfered with the tender process. There is no deviation from law in the particular judgment. Now, yesterday they pointed out to one that the single tender guidelines issued by the master company, that the Coal India. to say that when there is a single tender, you should not accept it. That was the submission. Maybe on different grounds for different reasons, you should not accept it. Ultimately, number one, in our counter, categorically, we have said that we have followed the norms. That is, we have mentioned in our counter para 30.
Yes.
There is a para 30 onwards. Then there's a categorical assertion and a submission that these norms have been followed. Number one. Number two, even if there is some kind of violation, that will not confer any kind of right in favor of the unsuccessful bidder. If the award contract, the award has been made, does not create any kind of legal right or enforceable right.
Yes.
At the most, the breach of these administrative instructions or the guidelines
Yes.
may be a reason for the authority which has issued the guidelines to look into the matter. That is the law which has been enunciated in 2007, volume 8, SCC 212.
Yes.
Kindly go to para 18 to 20, 18, 19 and 20. Para 18 onwards. 18. We are not inclined to agree that the non-adherence to mandatory instructions and guidelines contained in 704, 705 of the Vigilance Manual has vitiated the department proceedings initiated against the respondent by the Railway Authority. In our view, such findings reasoning are wholly unjustified and cannot be sustained. We have carefully gone through the contents of various chapters of Vigilance Manual so and so. The Railway Vigilance Organization, its role, investigation, so and so, so and so, so and so. They have then after about 6 lines, broadly speaking, the administrative rules after 6 lines. Broadly speaking, administrative rules, regulations, and instructions which have no statutory force do not give rise to any legal right in favor of the aggrieved party and cannot be enforced in a court of law against the administration. The executive orders appropriately so-called do not confer any legally enforceable rights on any person and impose no legal obligation on the subordinate authorities for whose guidance they are issued. Such an order would confer no legal and enforceable rights on the delinquent. Even if any of the directions is ignored, no right would lie. Their breach may expose the subordinate authorities to disciplinary or other appropriate action, but they cannot be said to be in the nature of statutory rules having the force of law, subject to the jurisdiction of the certiorari. It is well settled that central government or the state government can give administrative instruction to its servants how to act in certain circumstances, but that will not make such instructions statutory rules which are justiciable in certain circumstances. In order that such executive instructions have the force of statutory rules, it must be shown that they have been issued either under the statutory authority conferred on the central government or the state government by some statute or under some provisions of the constitution providing thereof. Therefore, even if there has been any breach of such executive instruction, that does not confer any right on any member of the public to ask for a writ against the government by a petition under Article 226 of the Constitution.
Yes. Yes.
From 3 angles, I am submitting. Number one, as I pointed out, we have categorically made the reply saying that that has been complied with. Number one. Number two, it does not confer any kind of right in favor of anybody to say so. Ultimately, that is another issue. Thirdly, this will not create any kind of benefit to them. Ultimately, if that is vitiated, everything is vitiated. The entire tender process will be vitiated. That will not confer any kind of right on them to get the contract awarded.
No, but they may argue
Yes.
that if the entire tender process is cancelled because
Yes.
of that,
Yes.
it is held to be illegal,
Yes.
then they will have an opportunity to participate again afresh.
But the yes.
This is what.
That is, I understand. But nevertheless, the clause remains this one. That's one of the aspects. I'll leave it as it is. Just from this angle, I'm pointing out. Now coming to the one of the aspects, the Malafites. The Malafites. No, where did you see? Oh. The writ petition filed by NCC Limited. The entire writ petition, there is not even a single sentence regarding Malafites.
Yes. Yes.
Law is as well settled. Number one, the Malafites must be number one, pleaded with clarity, and not only pleaded but also must be proved. This is right from A.C. Royappa's case even till the law holds the field same thing. So in the NCC case, absolutely there is not even a single sentence to show that there are any kind of Malafites. So that Malafites argument on the part of NCC absolutely cannot be argued at all, looked into at all. However, in the BGR matter, they have made some assertions by saying that there is a Malafide to the extent that to help another tenderer, his tender has been rejected. But these are all general pleadings, but I would like to read 2-3 paras what they have said about the Malafites.
Which paragraph?
One is in para 26, they have said. Then para 28. These are the 2 paras in facts. Then same thing, reiteration in the grounds in 2 paras. Writ petition pleadings, I am reading para 26.
26.
Yes, BGR.
Yes.
However, the opposite party number 1 has selectively disqualified the petitioner from the instant bidding process, while it has accepted the techno-commercial bids of the opposite party number 2. As such, the opposite party number has displayed clear favoritism and the petitioner has been discriminated against arbitrary, illegal, and in a malafide manner. That's one assertion. Then thereafter, para 28.
Yes.
That opposite party number 1's arbitrary, malafide action and favoritism is further clear from the comparison with their action pursuant to the tender for work of Lakhanpur OCP pursuant to the NIT number 172 of 16/3/22. In the said tender, the same bidders also submitted the bid to the opposite party number 1. Despite the conflict of interest clause in similar nature in said tender documents, all 3 participants, namely petitioner, opposite party number 2, NCC, qualified for the price bid. The conflict of interest clause in the said tender are extracted here below. They quote that particular one, conflict of interest clause. It is submitted, impugned decision of the opposite party number has interpreted the conflict of interest in a overboard and discriminatory manner and has violated the petitioner's right under 19(1) of the Constitution by imposing unreasonable, arbitrary, disproportionate restrictions on the petitioner's right to business so and so without justifiable reasons so and so, so and so, so and so. These are the only allegations of Malafides in the. That's right. Yeah. Then in the amended petition, in para 26A,
Yes.
it is submitted that entire tender decision-making process has been rendered palpably arbitrary and illegal and has also been vitiated by Malafides and favoritism. Opposite party number 2's sole financial bid has been accepted without examination and consideration of its reasonability in comparison to the market value. It is an admitted fact that in case of sole financial bids, opposite party number is bound to determine if the bid was reasonable in comparison to the market value under the provisions of chapter 6 of the contract so and so, so and so. The same guidelines. Yes. However, the opposite party number 1 has failed to undertake any such examination, thereby rendering the entire decision-making process so and so arbitrary and irrational. That's all. Number, the mala fide allegation number 1, it is vague. Number 2, not only the pleading, but also proof is required as well settled. There can be two kinds of mala fides. One is the actual and the legal. Legal with reference to the documents, which I already argued on that aspect. Then the actual mala fide is concerned, you have to specifically say what actually is the mala fide, who is instrumental behind it, what is the reason. These details are at least minimum details will have to be.
And he will have to be impleaded.
Impleaded. That is at another aspect. They have to be impleaded. They have to point out what is the role, how it has been done, why it has been done, what is the reason. Otherwise, it's very easy for any pleading to say that, yes, it's a mala fide, it's a mala fide, it has been done. Such mala fide allegations cannot even be looked into unless so on. But however, with reference to para 28, they refer to another previous document where 3 bidders have been qualified with reference to the particular document is stated in the petition. We have pointed out in our counter, that is in our counter, right? In our, yes, in a previous counter. Yes, in the counter. In para 27 of that, in earlier tender, like they are required to give this experience certificate. In the experience certificate, the very person NCC itself never disclosed any kind of this kind of relationship. And kindly look at the document which I have submitted in that tender process, that is at page number 255. Annexure N1 at page number 255.
Annexure M1.
N1. N1, page 255, right? 255 for counter, right? Our counter. Running page.
Counter page is 114. Oh, your counter is from 142 to 188. Oh, yes.
Internal page, I am told 114 and running page is 255, subject to corrections. I'm sorry if it is a discrepancy.
Just
I'm sorry, BGR is complete or
BGR.
17120.
Yes.
1712.
Just. Yes.
Yes. That is a e-procurement system of quality bid submission confirmation document.
Yes.
Bidder name is NCC Limited. That was in the other tender process, the tender document submitted by the petitioner. Now kindly turn to page number, next page 257, that's 116. Available service experience details.
Yeah.
Agreement so and so. Work description, drilling, excavation, transport is so and so. Value of experience, period of so and so, period of works so and so, so and so, so and so. Required so and so. Nothing was disclosed. At the time of whatever the document it is required to be disclosed, which has been disclosed, that will be assessed and based upon that the decision will be taken. And now actually by pointing out these things, virtually they are making to the submission would be the effect that they have suppressed certain things in that tender process. Maybe inviting for another litigation to tender the contract which has already been awarded. Anyway, that's a different issue altogether. But whatever it was there, on that basis, it has been evaluated and the contract has been awarded at that time. That a wrong decision which has been taken earlier by assuming that this particular document there was something that will not confer any kind of right. The equality, that is a positive concept that cannot be based upon some wrong which has been done earlier or anything. But however, nothing was done there. There, based upon this particular document, the information which was supplied. Here, that service document, the bid document, that experience certificate which has been furnished, that itself was very clear. Based upon that, we had to take a decision with reference to the tender norms. So that cannot be, it cannot be alleged as a malice action by saying that earlier we had granted, therefore you are bound to grant now. That at any rate that cannot be granted. Cannot. However, we have answered by categorically in para 27 of our counter.
Yes.
That in reply to the averment in para 27, 28 of the writ petition, it is humbly submitted that the opposite party in tender of Lakhanpur so and so, none of the bidders have disclosed any information regarding having conflict of interest, despite there is a clause regarding participating bidder must proactively declare such a sister common business management in similar so and so information of conflict interest. MCL could not have any knowledge about the same. That apart from the work experience certificates uploaded by the petitioner and the opposite party and other bidder, it is found out that is no conflict of interest. It is further submitted this opposite party that it has followed the clause of RIP in true spirit so and so, so and so. Then again, para 30 also, we have said about it. That's one part of it. And secondly, even the clauses except the conflict of interest, the definition with regard to associate, it is lacking in the earlier tender document. The tender document clauses, everything will be different in each tender document depending upon the need or depending upon the author of the document or the situation. So in a straitjacket formula, by saying that in a previous some tender process, his tender was accepted, therefore rejection in the subsequent tender, it is bad and it's a malified, that cannot be ground at all. This is with regard to the malified. Here the tender innovating authority, after examining all the records, after evaluating the situation based upon common shareholding, common signatories, or common directors and common address, with strict adherence to the terms and conditions of the tender document, have come to the definite conclusion that there is a conflict of interest. Ultimately, a person who is the unwilling person cannot be compelled to enter into a wedlock. We are entering into a transaction for over several years. Ultimately, it is the trust or which I have to repose on while inviting the tenders that the person is capable. It is good to have a commercial relationship with me for several years. Unless such a confidence is inspired at the beginning, even before entering into this particular wedlock or the contract, I must be satisfied. If such a decision is taken based upon certain norms and the fair assessment, then there can be no right on the part of a person to compel us to enter into a contract. Even law is also well settled that nobody can compel government to enter into a contract. Ultimately, when it comes to the distribution of the assets or the resources of the government, it must be fair and non-arbitrary. That has been done in the present case. By considering all these aspects, the rejection decision has been taken. It is strictly in accordance with law. Therefore, no justification at this stage is required. And one more aspect is subsequently contract has been awarded and work has been given to the other party, which is going on. That is subject to the outcome of the writ petition. This honorable court has ample power, whether it's correct or not, and all those things to decide. I not to get into that. Finally, any other further query or clarification is required from our side, I am here to this one to assist this honorable court. And only one word I would like to add before concluding. On one issue, both of us would be on addendum, that is the magnanimous accommodation to all of us, and also very patient hearing, which will be remembered for several years. We are grateful for such an opportunity, and
your arguments were quite educative, I must confess.
It's not, it's always pleasure. It's a very, very patient hearing.
At least we have something not to agree upon. Better.
It's one of the great experience we had.
Thank you.
I'm great.
Yes,
May it please,
you are here.
Please excuse my absence yesterday, my lord. I am sorry. I tried to log in. I had some argument, but my lord, there was some part-head matters which I could not have.
Before,
And before a special bench, sorry.
is the permission, my colleague will
Oh,
be here.
yes.
Any other clarification, my colleague will be.
Yes.
I'm great.
May it please. Lord, I beg to appear for BGR mining, my lord. The BGR mining writ petition for the respondent number 2.
Yes.
And I will be as short as possible, my lord, so that I don't need to repeat, and the learned additional solicitor general has already covered most of the aspects. So I would not like to. So, my lord, if I may be permitted to, my lord, put this matter first, my lord, in a perspective as has been held by Supreme Court in the UFLEX judgment. If your lordships have the compilation given by,
Yes, we do have.
you have, lordships have this 2022 1 SCC
Yes.
165. This perspective, my lord, is what I am requesting, my lord,
Yes.
for the purpose of your lordship's decision in the matter, my lord. I would like to start from there and then go to some facts and.
Yes.
2022
Yes, it is there.
1 SCC. Just a few paragraphs. my lord.
Yes.
Lord, may I just start with paragraph 1, my lord?
Yes.
The enlarged role of the government in economic activity and its corresponding ability to give economic largesse was the bedrock of creating what is commonly called the tender jurisdiction. The objective was to have greater transparency and the consequent right of an aggrieved party to invoke the jurisdiction of the High Court under Article 226 of the Constitution beyond the issue of strict enforcement of contractual rights under the civil jurisdiction. However, ground reality today is that almost no tender remains unchallenged. Unsuccessful parties or parties not even participating in the tender seek to invoke the jurisdiction of the High Court under 226. The public interest litigation jurisdiction is also invoked towards the same objective as an aspect normally deterred by the court because of this causes proxy litigation in purely contractual matters. The judicial review of such contractual matters has its own limitations. It is in this context of judicial review of administrative actions that this court has opined that it is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. This sentence your lordships have had occasion to read earlier, my lord. The purpose, of course, my lord, your lordships would have read all of this earlier also. I'm sorry. The purpose is to check whether the choice of decision is made lawfully and not to check whether the choice of decision is sound. That's one sentence which is important. For my purposes, my emphasis rather. In evaluating tenders and awarding contracts, the parties are to be governed by principles of commercial prudence. To that extent, principles of equity and natural justice have to stay at a distance. And my lord, the Jagdish Mandal case is also, my lord, at which my friend, my lord, the learned Solicitor General pointed out. We cannot lose sight of the fact that a tenderer or contractor with a grievance can always seek damages in a civil court and thus attempt by unsuccessful tenderers with imaginary grievances, wounded pride and business rivalry to make mountain out of molehills of some technical procedural violation or some prejudice to self and persuade courts to interfere by exercising power of judicial review should be resisted. The same para, my lord, which was read in Jagdish Mandal also. In a sense, the Wednesday principle is imported to the concept that a decision is so arbitrary and irrational that it can never be that any responsible authority acting reasonably and in accordance with law, would have reached such a decision. So it has to be so, my lord, the decision has to be so arbitrary and so irrational that nobody can reach that decision. One other aspect which would always be kept in mind is that the public interest is not affected. In the conspectus of the aforesaid principles, it was observed in Michigan Rubber as under. From the above decision, the following principles emerge. The basic requirement of Article 14 is fairness in action by the state, and non-arbitrariness in essence and substance is the heartbeat of fair play. These actions are amenable to judicial review only to the extent that the state must act validly for a discernible reason and not whimsically for any ulterior purpose. If the state acts within the bounds of reasonableness, it would be legitimate to take into consideration the national priorities. Fixation of a value of the tender is entirely within the purview of the executive, and courts hardly have any role to play in this process, except for striking down such action of the executive as is proved to be arbitrary or unreasonable. If the government acts in conformity with certain healthy standards and norms such as awarding of contract by inviting tenders, in those circumstances, the interference by courts is very limited. In the matter of formulating conditions of a tender document and awarding a contract, greater latitude is required to be conceded to the state authorities unless the action of the tendering authority is found to be malicious and a misuse of its statutory powers. Interference by court is not warranted. Certain preconditions or qualifications for tender have to be laid down to ensure that the contractor has the capacity and the resources to successfully execute the work. And if the state or its instrumentalities act reasonably, fairly, and in public interest in awarding contract, here again interference by the court is very restrictive, since no person can claim fundamental right to carry on business with the government. One other aspect examined by this court is whether the terms and conditions of the tender have been tailor-made to suit a person entity. In fact, this is what is sought to be contained in the facts of the present case. Now, next sentence. In order to award a contract to a particular party, a reverse engineering process is evolved to achieve that objective by making the tender conditions such that only one party may fit the bill. Such an endeavor has been categorized as decision-oriented systematic analysis, for short DOSA. The burgeoning litigation, now, this is another emphasized point for me, my lord. The burgeoning litigation in this field and the same being carried to this court in most matters was the cause which set forth an epilogue in Cartel Infotech. Even if it amounts to repetition, we believe that it needs to be emphasized in view of the controversy arising in the present case to appreciate the contours within which factual matrix of present case has to be analyzed. Then para 37 of Cartel now, my lord. We consider it appropriate to make certain observations in the context of nature of dispute which is before us. Normally, parties would be governed by their contracts and the tender terms, and really no repetition would be maintainable under Article 226. In view of the government and public sector enterprises venturing into economic activities, this court found it appropriate to build in certain checks and balances of fairness in procedure. It is this approach which has given rise to scrutiny of tenders in writ proceedings under Article 226. It, however, appears that the window has been opened too wide, as almost every small or big tender is now sought to be challenged in writ proceedings almost as a matter of routine. This in turn affects the efficacy of commercial activities of the public sector, which may be in competition with the private sector. This could hardly have been the objective in mind. An unnecessary close scrutiny of minute details, contrary to the view of the tendering authority, makes awarding of contracts by government and public sectors a cumbersome exercise with long drawn-out litigation at the threshold. The private sector is competing often in the same field. Promptness and efficiency levels in private contracts thus often tend to make the tenders of the public sector a non-competitive exercise. This works to a great disadvantage to the government and the public sector. In AFCONs, my lord, then the AFCON part is mentioned, my lord, which has already been placed. And thereafter, my lord, if I may take your lordships to the last 4 lines of that para 38 of this cartel. It has been cautioned that constitutional courts are expected to exercise restraint in interfering with administrative decisions and ought not to substitute their view for that of the administrative authority. Mere disagreement with the decision-making process would not suffice. Another aspect emphasized is that the author of the document is the best person to understand and appreciate. In the facts of the present case, the view of the interpreting the tender document of respondent number 1 must prevail. Respondent number 1 itself, appreciative of the wording of clause 20 in the format, has taken the considered view. Respondent 3 cannot compel its own interpretation of the contract to be thrust on the respondent number 1 or ask the court to compel respondent number 1 to accept that interpretation. In fact, the court went on to observe in the aforesaid judgment that it is possible that the author of the tender may give an interpretation that is not acceptable to the constitutional court, but that itself would not be a reason for interfering with the interpretation given. And then, my lord, the AFCON part of that judgment is quoted. Then, my lord, kindly come to the later part of the judgment where Nabha power, para 45, later part of that page rather. My lord.
Yes.
Para 45 of Nabha. Before discussing in greater detail the reasoning of the Court of Appeal, the board will make some general observations. This is the quotation from the Privy Council, my lord.
Yes.
The court has no power to improve upon the instrument which it is called upon to constitute, whether it be a contract, a statute, or articles of association. It cannot introduce terms to make it a fairer or more reasonable. It is concerned only to discover what the instrument means. However, that meaning is not necessarily or always what the authors or parties to the document would have intended. This is what Privy Council said, my lord, a long time ago, my lord. Then, if your lordship see, this in Trollope's case, Trollope and Calls Limited versus Northwest Metropolitan Regional Hospital Board, Lord Pearson's view, if your lordship will kindly come to the 8th line of that quotation. An expressed term, an unexpressed term can be implied if and only if the court finds that the parties must have intended that term to form part of their contract. It is not enough for the court, I'm sorry, lordships of contract. It is not enough for the court to find that such a term would have been adopted by the parties as reasonable men if it had been suggested to them. It must have been a term that went without saying, a term necessary to give business efficacy to the contract, a term though tacit formed part of the contract which the parties made themselves. Then, my lord, Nabha power also took note of the earlier judgment of this court in Satya Jain, which discussed the principle of business efficacy as proposed by Lord Justice Bhavan in Murok. It has been elucidated that this test requires that the term can be implied only if it is necessary to give business efficacy to the contract to avoid failure of the contract, and only the bare minimum of implication is to be there to achieve this goal. Thus, if the contract makes business sense without implication of terms, the courts will not imply the same. And then, my lord, Nabha power is again quoted, my lord. I am placing this para 72 at the foot of that page. We may, however, in the end extend a word of caution. It should certainly not be an endeavor of commercial courts to look into implied terms of contract. In the current day and age, making of contracts is a matter of high technical expertise with legal brains from all sides involved in the process of drafting a contract. It is even preceded by opportunities of seeking clarifications and doubts so that parties know what they are getting into. Thus, normally a contract should be read as it reads, as per its express terms. The implied terms is a concept which is necessitated only when the Penta test referred to aforesaid comes into play. There has to be a strict necessity for it. In the present case, we have really only read the contract in the manner it reads. We have not really read into it any implied term, but from the collection of clauses, come to a conclusion as to what the contract says. And then, my lord, the next para, we have considered it appropriate to once again emphasize the aforesaid aspects, especially in the context of endeavors of court to give their own interpretation to contracts, more specifically tender terms, at the behest of a third party competing for the tender, rather than what is propounded by the party framing the tender. The object cannot be that in every contract where some parties would lose out, they should get the opportunity to somehow pick holes to disqualify the successful parties on grounds on which even the party floating the tender finds no merit.
Yes. Yes, please. Please not. Oh, realize or.
Please, Lord, please. Sorry, Minister. Now, Lord, now, keeping that in perspective, I am just placing a short list of dates of what facts have transpired in this matter. And then, my Lord, court must. Udhar dijiye.
Yes.
I place it. 17/11/2022, Mahanadi Coalfields decided to undertake development and operation of such and such through a mine operator for excavation and delivery of coal. Accordingly, floated a global notice inviting tender for the development and operation. 24/11/22, the global NIT was widely advertised and sent to different chambers of commerce as well as to trade commissioners of embassies of 11 countries. An advertisement was also published in 5 leading regional newspapers. Lord, these are all gathered from the counter affidavit of the Mahanadi Coalfield. Let me place that correct. And from the writ petition. 5/12/22, as per clause 6 of the NIT, a pre-bid conference was held at the MCL headquarters at 11 a.m. by video conference. This was attended by 8 prospective bidders, members of the tender committee, representatives of the CMPDIL, that's the Lord Coal Mine Institute, officers of the MCL. 13/1/20. During the period of seeking clarification, 4 clarifications were sought. These were clarified. 16 to VPR Mining Infra, BGR, and NCC submitted the bids for the aforesaid project. Part 1 and Part 2. The scheduled date for opening was such and such. Date was rescheduled. 18 to MCL opened technical bids under clause 3.5. The bids of so and so were admitted for technico-commercial evaluation under 3.8.1. 6th March, as per 3.8.1, the tender committee examined the techno-commercial bids by scrutinizing their documents. 15/5, after the techno-commercial evaluation, so, my Lord, this is over a period of more than 2 months, my Lord. VPR was declared to be the sole bidder eligible for price bid. However, on the other hand, BGR and NCC were disqualified under such and such on the ground of conflict of interest and under clause 4.1, read with 4.3d, for engaging in undesirable practice. In reaching the aforesaid decision, MCL was guided.
So the
by
disqualification and opening of the price bid,
yes,
whether 2 were simultaneous or one
no, my
after
Lord,
the
the
other?
price bid was later on.
Because it is on the
The
same
dates
day.
are there, my Lord. My friend has in the writ petition annexed both the documents, my Lord.
No, both are of the same date.
Yes, it is. They are of the same day. 15/5.
15/5.
Please, my Lord.
Therefore, whether they were simultaneous or subsequent,
My Lord, there is a time mentioned on the page. If your lordships kindly come to page 50, page 49 first, and then at page number 52. On 52, of course, there is no part.
51 days. 51 days said that they will open at 11 a.m.
Yes. My Lord, 51 say, if I may show page 49 of the writ petition, the BGR writ petition, my Lord. That is 17120 of 2023. This is something which they have annexed as Annexure 1.
You just tell us what is mentioned there.
It says 15th May, 11:46 a.m. This was on the portal. But at the same time, if your lordship see, the document which is at page 51, at the foot of that page, 51, the price bid of eligible bidders will be opened on 15/5 at 11 a.m. as per clause such and such. Your Lordship's got that. So this is how, my lord, it happened. Now, the putting it on the portal would have preceded by whatever the tender committee discussed. And that, your Lordship will find at page number, my lord, 157 of the other writ petition 17188. Just kindly come there, my lord. The timing is are mentioned for the purpose of being clear on this, my lord.
Yes.
If your Lordship see the last column, this is the rejection letter which with the reasons which is given for both and which is identical.
Yes.
Your Lordship will find status updated on 15th May 2023 at 10:23 a.m., 10:23 a.m. My Lord's got that on the last column of page 157.
So is this your case, or it should be your case, otherwise it may be very difficult for you, that they were disqualified first
Yes, my lord.
and thereafter
Thereafter, my lord, it says the last one says
price bid was opened.
admitted and then referred to finance. And then if your Lordship see on that very page later part, technical bid summary opening by so and so 18th February 2023, that we can leave, and then technical evaluation summary details. Here, my lord, and the last page, the committee members and the chairperson, there are 11 committee members and 1 chairperson whose names are mentioned. And your Lordship will see even on the next page top, updated on 15th May 1023. And then it says financial bid opening date 15th May 11 a.m. And then, my lord, the next para or the chart shows the price bid of one technology so and so was opened 15th May 11:41 a.m. So it has, my lord, after the disqualification, then the price bid has been opened. This is the document which my friend the NCC matter has filed, and the other document which I have showed at 49 and 51 are what my friend the BGR people have filed. And I'm not joining issue on that, my lord. And there is no no statement on this basis that there is something kind of that there was some in a hurry or something.
No. There is two things. In fact, both the processes were simultaneous, or the price bid was open later.
My lord, if your Lordship see the clause, if I may just show the clause, my lord, of the both to be opened, it's mentioned here. Just give me one moment, Lord. 3 point something. 3 point evaluation. Yes, my lord.
Only to save your Lordship's time on this, our whole case is that 3 months they kept waiting. Our offers were of February, they opened on May, and hurriedly did everything. So it's not our case that it was done simultaneously.
It's all right.
I don't want to, I should your Lordship.
All right. Then you can proceed, Mr.
Please. But my lord, at clause 3.8 deals with the evaluation. 3.8.1 at 115 of the writ petition of BGR shows techno-commercial evaluation of tender. And thereafter, my lord, 3.8.2 says determination of L1 tender. Now, my lord, if I may proceed with this list of dates. Now, my lord, after this, the MCL opened the price bid, and then 15/5 Annexure 6, MCL issued a show cause notice to the disqualified bidders, directing the disqualified bidders to show cause as to why they should not be debarred and blacklisted from participating in any future tender floated by Coal India or its subsidiaries. As per MCL, NCC and BGR have a shareholding of 51 and 49%, respectively, in an SPV called PCMPL. In fact, SPV is currently executing a project as a mine developer. Then over the page, my lord. Furthermore, NCC and BGR are also associated through another party, the TCMPL. The entities share a common address and also have overlapping directors. Disqualified bidders have access to information and are in position to influence. 15.5. BGR and NCC addressed letters to MCC requesting it to revoke their disqualification and to allow them to participate in the price bid. MCL asked the general manager of Northern Coalfields where there exists any ongoing contract in the Khadia project or any other project by a JV consortium formed between BGR and VPR. That VPR is me, Milord. 19.5, GM Northern Coalfields informed MCL that there is no ongoing project between BGR and VPR and that the Khadia project was completed on 31/8/2022. 19.5, BGR and NCC filed writ petition so and so respectively before this court assailing their disqualification. 23.5, this honorable court was pleased to issue notice in the interim. MCL was permitted to proceed with the evaluation process, but not grant tender. That word, three words are missing, not issue the LOA. And these orders were continued. 12/6/23, during the evaluation of price bid, the tender committee by way of a letter dated 12/6 sought price justification from VPR under clause 3.9.1. MCL issued a letter to Central Mine Planning and Design Institute to submit a report on the viability of the project. So, both the letters were simultaneously issued. One to the VPR and the other to CMPDIL. VPR suo motu revised the quoted mining charges from such and such. And then MCL requested CMPDIL to submit a viability report on VPR's revised quoted price, that is at page 108. Yesterday, Mr. Naidu showed this, of the same day, 13 June. The CMPDIL found the revised quoted price as reasonable and viable, which is mentioned, in the second line at the top of that page. Lordships may kindly mark there at page 23 of the counter affidavit of MCL. It is so stated, Milord. And because they have raised a ground, therefore I am, pointing. Just kindly make a note there. Page 23, at the top of the page, this is what is stated in the counter. Accordingly, CMPDIL has evaluated and submitted a report on the viability of the project, basing upon the revised price quoted by opposite party number 2, and opposite party number 1 found that the project for the work of development and operation of such and such is reasonable and viable, and accordingly, LOA of 28 and work order were issued and agreement was executed. That's what I wanted to. So, Milord.
Yes.
Then, Milord, the subsequent development, 28/12 MCL issued a letter of acceptance. Then 3.1 BGR and NCC, this is important, Milord, addressed an email to MCL wherein the disqualified bidders requested MCL to revoke the forfeiture of the earnest money deposit and withdraw the show cause notice. This is, Milord, immediately after, Milord, within 5 days of, Milord, the letter of acceptance having been given to us, and about 15 days from the date of the earlier judgment of your lordships. On 3/1/24, pursuant to letter of acceptance, VPR furnished a performance guarantee. 12/1/24, in terms of clause 2.2.6, VPR formed a special purpose vehicle in the name of so and so. 19/1, MCL issued a work order. 21/24, MCL issued a notice for personal hearing to the disqualified bidders in respect of show cause notice dated 15/5 in relation to the blacklisting. And Milord, just have it, kindly make a note, Milord, that that is missing there the date. 8/2/2024. 8/2/2024.
Yes.
Just 1 minute.
What happened?
Milord, the personal hearing took place.
Yes.
And a letter was written, which is at page 66 of the writ petition of the BGR, to the respondent number 1 for refund of the EMD and abstain blacklisting. Another one. Lord, if your lordship will permit me to place this page 66 of their writ petition, it may be a little relevant, my lord, for the purposes of
Which annexure is that?
page in my lord, writ petition 17120,
Yes.
writ petition annexure 6D, 6 capital D.
Yes.
My lord, the second page of it, my lord, page 67, the last 3 paragraphs. We humbly remind your good office that it was only at your request we assured you that we would not resort to any further legal action, litigation in the event our request to refund our EMD amount and not to debar BGR from participating in the future tender is considered. However, till now, there has been no action taken from your good office to resolve the issue on hand. Any further delay in resolving the present issue will put immense pressure on our company, as we would not be able to participate in other tenders in view of the forfeiture of EMD, which will result in huge financial loss. As such, we again request your good office to resolve the issue as prayed by us in the personal hearing held on 24/1 by refunding our EMD amount and not taking any further coercive steps against us at the earliest.
Yes.
This is what they wrote, my lord, on 8th February.
So this is a part of your counter affidavit?
No, my lord, this is a part of their writ petition.
No, this is 6D.
This is the amended writ petition, my lord.
Okay.
Part of their writ
All right.
petition.
We understand. Yes.
Now, my lord, I'll come to the next date now, my lord. 29/2, pursuant to the letter of acceptance, MCL and VPR
So
executed a contract agreement.
Is there any
Inter-
decision on refund of EMD?
Sorry,
No.
my lord.
Is there any decision on the request for refund of EMD?
The decision was taken, that decision is coming now, my lord, in 12th of April. They said that as a concession for you, we will not blacklist you, but we will not refund the money.
What is the amount?
2 crores. 2 crores each.
All right. Yes.
My lord, that also my friends have annexed at page 69. So, my lord, after that, the contract was executed on 29/2, and thereafter, my lord, on the next page, last page, my lord, of this list of dates, the Government of India issued notification under Section 9(1) of the Coal Bearing Areas Act, Acquisition Act, for the acquisition of land that are required for execution of the project. 12/4/24, MCL wrote a letter to both the disqualified bidders, stating that their bid securities stood forfeited as damages, but they were not blacklisted from participating in future tenders as a one-time concession. 16/5, the Government of India issued notification under Section 11(1) of the Coal. So it earlier was the 9(1), my lord, and then to 11(1) requesting to make payment towards the acquisition of land. Now, my lord, much after they had all requested this, they went to the Supreme Court only on 15th March and 18th March. BGR filed so-and-so and NCC filed so-and-so. And then the orders and judgments of the court, my lord, remanding is on 26/4 and 6/5. And then 13th May, your lordships, my lord, allowed their amendment application.
Yes.
So this is, my lord. So only to show, my lord, that there has been participation, the tender has been properly, people came forward, people did not apply, some 8 people, my lord, came for the pre-bid meeting, etc. So this is only to show that. So I wanted to, my lord, just place this. Now, my lord,
Just a minute.
sorry, my lord, I'm so sorry.
Yes.
My lord, apropos your lordship's query, observation regarding, my lord, the timing. My lord, there is something mentioned in the counter affidavit of the Mahanadi Coalfield. If I may be permitted to just place that para.
Just.
That para 22, my lord,
Please.
at page 25.
Yeah.
May I place that, my lord? At the
Yes.
foot of page 25,
Please.
your ladyship has it. That in reply to the averment made in para 13 of the writ petition, it is humbly submitted by this opposite party that it is a usual practice that price bid is opened on the same day after completion of online techno-commercial evaluation. Copies of earlier similar tender of which the price bid opening time specified in the techno-commercial evaluation summary are annexed for better appreciation. Since the petitioner's price bid was not decrypted and opened, hence this opposite party has no information about the price bid of the petitioner. So, my lord, this is what the averment is there with reference to your lordship's query, my lord, whether it was on the same day. And so after the techno-commercial evaluation, sorry, my lord, not techno-commercial, techno-commercial evaluation, that is 100.
Yes.
And my lord, 3.8.1 of the tender document also shows that. So now, my lord, if I may just now show some of the terms and conditions of the tender document. Your lordships have been taken through it several times. And in fact, on the first day, my lord, I had practically shown all of them.
We do that.
Please, my lord, I'm like, but I'll just quickly, my lord, trouble your lordship with this.
Yes.
So, my lord, the RFP starts at page 86. And at page 92 is a disclaimer clause. Now, my lord, at page 93 top, my lord, first two sentence lines, and then the third para and the fifth para. By acceptance of this RFB, the bidders agree that information contained
Just a
herein
minute, you are
supersedes
referring to
the
page-
disclaimer in the
No, you are referring to
BGR writ petition. Sorry, my lord, 17120.
yes. So which annexure is that?
Sorry. And annexure number is, my lord, 7. Annexure is it's part of annexure 7. It's the NIT, the whole NIT, my lord, starts from page number 70. Global notice inviting tender dated 17/11/22.
Yes.
In that, my lord, I am requesting your lordships to kindly have the request for bid. The RFB starts at page 86.
Yes.
Continuing page. And in that, there at page 92 is the disclaimer clause in the RFP.
Just.
My lords have it.
Which clause is this?
My lord, there is no clause numbering in the disclaimer. I am requesting your lordship.
What is the internal page?
Internal page is 7 at the foot of the page.
Oh.
Internal page is 7 at the foot of the page. This 7 is, my lord, in the request for bid, because earlier there are internal pages for the NIT. So that goes on for up to page number 15, 16 rather.
Yes.
And then, my lord, 86 onwards is the request for bid, internal page 1 at the foot, and at page 7, at 8, my lord, I am requesting your lordship to place 3-4 lines.
Yes.
At the first 2 lines, my lord,
Yes.
at 93, which is internal page 8.
Yes.
By acceptance of this RFB, the bidders agree that information contained herein supersedes documents or earlier information, if any, in relation to the scope of work project. Then, my lord, the third para. The issue of bidding document does not imply that the authority is bound to select a bidder or to appoint a successful bidder for the project. Authority reserves the right to reject all or any of the bidders or bids without assigning any reason whatsoever. Then, my lord, the sixth para. The authority is not bound to accept any or all the offers. The authority reserves the right to reject any or all the offers without assigning any reason. The authority further reserves the right to negotiate with any or all bidders in relation to their offers. No bidder shall have any cause of action or claim against the authority of so and so, so and so, for rejection of its offer.
Yeah.
Then, my lord, your lordships may kindly come to page number, internal page 13, where section 2, instructions to bidder start, my lord. Running page 98.
Page 13,
Internal page is 13.
13, yes.
Running page at the top is 98. Instructions to bidders, general. Now, my lord, if your lordship see 2.1.6 on that very page in the later part, my lord, almost at the foot.
Yes.
Non-compliance with any of the bidding instructions may lead to rejection of the bid. So, my lord, this is very clear. Non-compliance with any of the bidding may lead to rejection. And then, my lord, eligible bidders, which has been quite a bane of contention, my lord,
Yes.
at page 99. Bidders may submit a single bid or a consortium formed by a maximum of 3 members which satisfy the qualification criteria stipulated in the bidding document. Where the bidder is a consortium, it shall comply with the conditions set out in clause 2.2.7 below. That 2.2.7 is at page 103. Then B. Because, my lord, your lordship will recall the rejection is specifically under 2.2.1 into bracket B. None of the sub clauses are mentioned. A bidder shall not have a conflict of interest that affects the bidding process. Simpliciter, one line. A bidder shall not have conflict of interest that affects the bidding process. Then, any bidder found to have a conflict of interest shall be disqualified. That's the second, Lord, clear. In the event of disqualification, the authority shall be entitled to forfeit and appropriate the bid security or performance security, as the case may be, as mutually agreed genuine So what is the forfeiture for? Genuine pre-estimated loss and damage likely to be suffered and incurred, and not by way of penalty for inter alia the time, cost, and efforts of the authority. That the damages has been, that is the way, without prejudice to any other right or remedy that may be available to the authority under the bidding documents and or contract agreement or otherwise. Now, my lord, there is a deeming fiction here now created for certain categories. Other than that, a general thing is there, my lord, of a conflict of interest. A bidder shall be deemed to have a conflict of interest affecting the bidding process if the bidder, its member or associate, or any constituent thereof, and any other bidder, its member or associate, or any constituent thereof, have common controlling shareholder or otherwise ownership interest. Let's pause here. So what does it say? A bidder, its member or associate, and any other bidder, its member or any associate, including constituents thereof, have common controlling shareholders or other ownership interest. Now, both these companies, let us understand what these TCMPL and PCMPL are. They are registered companies under the Companies Act, being a separate legal entity with shareholding and directors and having all the rigors of the Companies Act attached to those companies. In those companies, you have a shareholding. Admittedly, you have yourself disclosed that you have a shareholding. Now, if you have a shareholding, then just the first 3 lines is sufficient, my lord. The proviso I will come to just now, because this is on the deeming fix, that these will be deemed. What other conflict of interest can be has not been defined, but it says any conflict of interest. So, a bidder, its member or associate, or any constituent thereof, and any other bidder, its member or any associate thereof, or any constituent, have common controlling shareholders or other ownership interest. Lord, assuming one of the arguments is 49% is not controlling, etc. Lord, which I beg to disagree, because a control, my lord, above 26% is all controlled under the Companies Act. But be that as it may, or other ownership interests would take care, my lord. Now, what does the proviso say? That if those are less than 5%, then you will not be counted in it. It says, provided that disqualification shall not apply in cases where the direct or indirect shareholder of a bidder, member, associate thereof, or any shareholder thereof having a shareholder of more than 5% of the paid up share of such member, or so as the case may be, in the other bidder is less than 5% of the subscribed paid up capital share capital thereof. Then, my lord, the second proviso is not in issue here, my lord. So, my respectful submission for an interpretation of this is that the first 3 lines, based on documents submitted by my learned friends' clients in their bid documents, itself showed common controlling shareholder or other ownership interest.
Yes.
Now, my lord, thereafter, my lord, what does it say? For the purposes of this clause, 22.1 or 2.2.1b, indirect shareholding held through one or more intermediate person shall be computed as follows. Then double A, any intermediary controlled by a person through management control or otherwise, the entire shareholding held by such controlled intermediary or any other person shall be taken into account for computing the shareholding. So, my lord, even if you are an intermediary and you have some kind of amendment control and you have some shareholding, that will be taken into account. And then BB is subject to A, where a person does not exercise control over an intermediary which has a shareholding. The computation of indirect shareholding of such person shall be undertaken on a proportionate basis. So it talks of a proportionality there.
Yes.
And then it says, provided, however, that no such shareholding shall be reckoned if the shareholding is less than 26%. So we are not, this is not a case of less than 26%. 49 and 51 is admitted position. Now, my lord, look at 2 now, my lord, kindly. A constituent of such bidder is also a constituent of another bidder. Now, this SPV, where we have 49 and 51, is a constituent. That SPV,
The Roman 2 may not apply because it
Blood,
applies
blood,
only to the bidder.
please. So, constituent of such bidder.
Constituent of such bidder.
Constituent, blood, the SPV is the constituent of such bidder, is also a constituent of another bidder. The other bidder is, blood, there are 2 bidders, and both of them have this SPV together, and they are a constituent of each other. In my respectful submission. It is not, my lord, that they are divorced. Both are, sorry.
Oh, right. Yes.
Both are, my lord, bidders, and both are having constituents, and the constituent is located in the SPV. So therefore, I am making that respectful submission, my lord. Then, my lord, the 3 your lordships can.
Just one.
Sorry, I'm so sorry. That constitute, sorry.
The confusion is over this. Constituent of such bidder is also
Also a
constituent of another bidder.
Yes, so Milord, the
Alright, so we
constituent is
have-
one.
No, we don't have to see the third party first, SPV.
Please,
SPV is a third company.
please,
Here it says constituent of such bidder
yes,
is constituent of another bidder.
please,
So whether the constituent of NCC
yes.
is
Also a
constituent.
constituent of BJR.
No. BJR, no, BJR, in the BJR, they don't have any association. They have association in some other,
In the SPV,
in SPV.
yes.
So none of the bidders are constituent of
That's right.
the
Each-
other.
No, Milord, the bidder
Mr.
per
Kumar,
se,
if I may interrupt,
sorry, Milord.
that means common constituent, that
Yes.
both the bidders must have a common
Yeah,
constituent.
the
because
the common constituent is the SPV.
that is a different.
No,
It is
Milord,
not a common constituent.
no, Milord, what in my respect, what
Yes,
in
yes,
my
your
respectful
submission.
submission would be a constituent. Let us, Milord, then.
Constituent is a part of something.
Yeah, so Milord, is 51% shareholding or a 49%
No,
shareholding?
sir, the question is that SPV
Yes,
consists of both
yes,
the bidders.
please.
So both of them are constituents
There.
of that SPV.
Yes.
But SPV is not a bidder.
No, that I'm not denying that. I'm only putting it, Milord, the reverse of what my Lord observed just now. I am saying that a bidder has a constituent. Now that same constituent has also is part of the other bidder.
But is that correct? It is part of another, let's say that SPV. It is not part of, like, constituent of BGR is not a constituent of NCC, but a constituent of BGR and a constituent of NCC are constituents of SPV.
So, Milord, what your lordships are putting to me is that because both the companies are located in one company, that is the SPV. Now here we have two SPVs.
Yes,
We don't have one.
we have three.
So there are two constituents. Now, if your lordship look at it from that angle of two constituents, PCMPL and TCMPL, both have shareholding, both have a common address,
Therefore, you can rely on
The other.
Roman 1.
Roman one, I'm relying.
Better
I'm
to-
saying why I endeavored to put this was not. May I make myself clear that it is not that the 2.2.1.b comprises of 5 of them or 6 of them. It is not referable to just one of them. Is my respectful submission, because I have also shown, my lord, within that B1 I have shown, and then B2 I am trying to show, my lord, subject to what your lordship holds, and then come to straight away to 5 now. May I place 5 now?
Yes.
Such bidder. Now, my lord, I'll just skip that part and slowly read what I want to say, and then I'll read both again. Such bidder, its member or any associate. So I'm just reading such bidder has a relationship. So kindly mark the word relationship. Arising due to such and such with another bidder. So such bidder has a relationship with another bidder directly or through common third party. So I am saying this common third party relationship is the 2 SPVs. That is my respectful submission. So relationship through common third party and parties also. So there are 2 parties here. That puts either or both of them in a position to have access to each other's information about or to influence the bid or either of or such each other. So, my lord, the respectful submission vis-a-vis 5 is that such bidder and other bidder and having a relationship with a common third party. I don't need to, my lord, read its member or any associate. If we go that far, we could also apply that. But I am only on just this, such bidder with another bidder has relationship through a common third party. That's all. Gotcha. So, my lord,
Won't that apply to OP2 also?
no,
Because-
why it will not apply to me, my lord, is that so far as my project is concerned, it was already over from before, in 2022, before this tender was even floated. That is,
You were saying there's no longer any relationship.
there is no longer any relationship. Secondly, my lord, based on what my friends have argued, if I have understood them correctly, is about between an SPV and a consortium. Now, let me explain, my lord. As I submitted earlier, my lord, SPV is a separate legal entity bound by the rigors of the Companies Act because it is formed under the Companies Act and it is given a separate name.
No.
A consortium is like, sorry,
Mr. Ranjit, the question is different.
sorry.
Let us forget whether SPV is a juristic person, separate legal
Please.
entity or not. Let us understand the plain thing, Roman 5.
Yes.
It doesn't say, it just says that has a relations.
Yes. So has would be in the present, my lord?
In the present has a relations
Yes.
with another bidder.
With another bidder through a common third party. That's what I said. Lord, just to clear myself. Lord, why does it say relationship due to ownership, holding, cross-holding? So, my lord, ownership, holding, or cross-holding are all terms arising from the Companies Act. Now, if there is an ownership of shares, holding of shares, cross-holding in between, all three, my lord, come into being. Now, this happens in a legal entity because these are terms arising from the Companies Act. Whereas a consortium is in like a agreement where somebody is a lead member, there is no holding or cross-holding as such, and you get together with your work experience and what you have done in the past and apply together. So that is the vital difference between the juristic person and a consortium. So I am respectfully submitting that for this case, the entire case falls within 2.2.1b, and any of the 5 clauses, if it were to apply, it is sufficient for the purpose of holding that there is a deemed conflict of interest. Other than the wider term of conflict of interest, which is in the first sentence of 2.2.1b. And my lord, added to that is the fact that whether the authority committed such a mistake or was so unreasonable at arriving at this conclusion that nobody could have arrived at this conclusion is the other question. That no general person in general commercial terms would have come to this conclusion is the other part of it. Now, my lord, And a common third party, my lord, here would not be a consortium. It would not be a consortium.
Even a consortium could participate in the
Please,
present tender
please,
process.
please. And that is provided at, my lord, if your lordship go over the page, at page 103, internal page 18, 2.2.7, consortium requirements are mentioned there. Consortium is provided for. Kindly come to internal page 18.
Yes.
My lord.
Just as a clarification, Lord, consortium could apply, but they had to ultimately form SPV within this. That is the 2.2.6.
SPV I have formed here also, my lord, afterwards.
No, I'm not saying.
I have also formed, my
Your
lord.
lordship's
So
query only.
my friend will get an opportunity. And my lord, here that clause, which is that, my lord, in that subsequent, that Coal India, which has clarified, they gave a note, my lord. My friends have argued regarding a note that if member partners of any consortium involved in the participation or execution of some other project participates in the present tender as an individual or as a member, the same shall not be construed as conflict of interest, which came as a clarification by the Coal India, my lord. Your lordship will recall, my friends, that is the part of
Rejoinder dated 25th September by NCC.
25th September 2024, rejoinder filed by my friend in the NCC matter.
Has it been
The
scanned?
annexure 16 is there.
Scanned ultimately?
Annexure 16 of that, in that the clause, the note is there. So that note itself, my lord, showed that there was a conflict of interest earlier and now it doesn't. Sorry, my lord, I stand corrected. It clarifies the position as it already existed from before. That note, which your lordship will find at page number 24, internal page 21 of that annexure 16 to the rejoinder affidavit dated 23rd September. 25th September, sorry.
Yes.
Now, my lord, if I may proceed further. So, my lord, at page 103, internal page 18 of the bid document, in case the bidder is a consortium, the following requirement that is mentioned there, my lord. And then your lordship may kindly come to page 106, internal page 21, 2.6. In 2.6.1,
Yes.
it shall be deemed that by submitting a bid, the bidder has, and then, my lord, number F on the next page, acknowledge that it does not have a conflict of interest.
Yes.
So this is an acknowledgement by the bidder.
According to them, there was no conflict of interest.
No, but that of course, but so therefore, what I am respectfully submitting, it is for the authority to decide, the tenderer to decide, my lord. The person who has floated the tender, that interpretation is based on what is the definition given in 2.2.1. So the interpretation is based on that. Now, my lord, now in 2.7 on the next page, just kindly have a look at 2.7.1. The heading is right to accept any bid, negotiate and to reject any or all bids.
It is on.
One of the argument was, my lord, that there could not have been the price could not have been reduced. Notwithstanding anything contained in this RFB, so there is a non-obstante clause, the authority reserves the right to accept, negotiate or reject any bid and to annul the bidding process and reject all bids in whole or part at any time without the liability or any obligation.
Yes.
So therefore, my lord, this negotiation word, which your lordships also saw in the disclaimer, is there, my lord. And then at page number, my lord, internal page 26, running page 111 of this counter, of this writ petition, 2.16.6 on the later part of the page, 2.16.6. The bidder shall be, bid security shall be forfeited as damages without prejudice to any other right or remedy that may be available to the authority under the bidding documents and or under the contract agreement or otherwise under the following conditions. If a bidder engages in corrupt practice, fraudulent practice, coercive practice, undesirable practice or restrictive practice as specified in section 4. So, my lord, this undesirable practice is defined in 4.1, which I'll come to, my lord, which is also mentioned in the rejection order. And then at the foot of that page, last two lines, in addition, upon the occurrence of any of the above set out condition, defaulting bidder shall be debarred and blacklisted. That, of course, my lord, they have given that concession. And at page 115, internal page 30, 3.7.
Which clause?
3.7 minute. Clarifications by authority. Can I place it below?
Yes.
To facilitate evaluation of bids, the authority may at its sole discretion seek clarification of from any bidder regarding its bid. Such clarification shall be provided within the time specified, etc. The letter that was written to my client on 12th June for justification of my price bid, while simultaneously writing also to the CMPDIL for price justification, there was nothing wrong because it is covered here in 3.7.1. So, my lord, this clause is important for the purpose of meeting their argument, my lord, that could not have been done.
No, the what we understand,
please,
that had there been three competitive bidders,
please,
that clarification might have gone to all the three.
Please.
Here, because there was no
please,
other bidder which was qualifying.
Please.
Therefore, that communication was to be sent, and therefore it was sent under this 3.7.
Please. So, in my understanding, it is sent under the power vested in the tenderer authority under this.
Therefore, the writing letter seeking clarification, there was nothing wrong in that.
Please.
It is not that the letter was written to this your client only, because the letter was written because you were the only person.
Please. Please, my lord.
Who was fine.
I was the only person there, my lord.
So,
and that single bid is also to be get.
Yes.
Then, my lord, And this 3.8, my lord, this evaluation bid, this 3.8.1 techno-commercial evaluation started on 18th of February, as I put it in my list of dates.
Yes.
And then, my lord, the bids do not meet the requirement, etc., rejected. And only one thing, my lord, just to, on the basis of what who comprised it's important for me to show who were the people who evaluated the bid. There were 12 people of very high ranking officers. Just kindly allow me to place 157 page once again of the writ petition of NCC. Just allow me to place that. Because who was there to evaluate?
Just a minute, Mr. The other, you are referring to?
I am referring to writ petition 17188, annexure 4 at page 157.
Yes. Yes, please.
Please, kindly come to the foot of that page, my lord. The very foot. Technical evaluation summary details, committee chairperson coordinator name, so-and-so director technical operation.
You are
At the foot of page 157, annexure 4.
Yes.
In that printed page, my lord.
Yes.
It's kind of printed, my lord.
Technical evaluation summary details.
Yes, my lord's got the page.
Yes.
Now kindly see committee chairperson, so-and-so, director so-and-so. Then my lord, last line, committee members. My lord's got that.
Okay.
The very last line of that. Sorry, your lordship.
This is annexure 4.
Annexure 4 of the writ petition of NCC.
The very first page of annexure 4.
Yes.
Technical bid opening summary.
Yes, my lord. Below that, there is another column.
Technical evaluation summary
details. My lord got that.
Yes.
In that, the committee chairperson name is given. And the last line of that says committee members.
Yeah.
My lord's got that.
Yes.
There is one GM CMC, then there is GM production, GM PNP, GM executive, GM ENM, GM system S. Then over the page, GMC, GM SDG, GM LNR, GM HA, and DGMF.
All officers of the MCL.
11 plus one chairperson.
Everybody from MCL.
It's part of the committee member in the evaluation.
CMC means what?
Sorry, Milord.
CMC means what?
Milord,
CMC.
Milord, MCL will be able to.
Management cell.
Huh? Contract management.
Contract. Yes.
So, Milord, 11 members plus one chairperson. 12 persons have evaluated. To say, Milord, that there is something wrong, Milord, because I am on the decision-making process. And whether it could reasonably have arrived at a conclusion of conflict of interest. Sorry.
First page. Okay. The next is 4. Sorry. 4.
Ladyship has it. Page 157 in the other writ petition, NCC.
Oh, so it is
Annexure 4.
sorry, MCC.
That is 17188. Writ petition 17188.
All right.
I'm very sorry, ladyship. So, my lord, only answering this question, my lord, that if at all they are alleging any malafide or anything, some officer's name, somebody who did this, somebody who did that, something to be proved, or the decision was not taken accordingly. What is being today argued is an interpretation which they want your lordships must accept, which your lordships are not bound to accept. If your lordships feel that a reasonably arrived at conclusion by the tendering authority is right.
Yes.
So I'm only showing this for that purpose, that how many people were involved in the evaluation. This is apropos, my lord, that 3.8.1.
Yes.
Now, my lord, over the page, internal page 31, is the determination of the L1 bidder.
In that case, in the first 117.
116, running page, internal page 31, just the
okay.
very next page.
Which
I'm sorry, of the first writ petition. I'm sorry, my lord, the Chief Justice is asking, but I'm so sorry, I didn't get it. 17120 of 2023. 17120 of 2023 in the writ petition, internal page 31, running page 116.
Annexure.
3.8.2.
Yes.
Annexure is 7.
Yes.
My lords have the clause, ma'am, before your lordship.
Yes.
Yes. Oh, sorry.
3.8.2.
Internal page.
Internal page 31. 3.1.
Page 116. That we have.
Yes, please.
May I place it below? The price bid will be opened after the evaluation of part 1. That is, the part 2 of only the commercially acceptable bidders who have qualified shall be decrypted and opened on the scheduled date and time for which an intimation will be given to such commercially acceptable bidders through e-procurement portal. So the price bid opening is here, my lord, and then selection, my lord, is in 3.9, and which my friend, my lord, Mr. Naidu placed, my lord. Subject to the provisions of this RFP, this bidder whose bid has been determined to be substantially responsive and who is established as commercially acceptable L1 bidder shall be considered as the successful bidder for award of work, subject to the reasonability of L1 price and viability of the project, and for the authority on price quoted by L1 bidder. And
all this has been done on 15/5.
This is not, my lord. After this 12/6, Lord, 12/6, after your lordship passed an interim order that you can proceed with the tender process but not grant. 12/6, the letter is written for seeking justification. Because after 15/5, immediately they filed a writ.
No, but the price bid was opened on the same day.
Yes, price bid was opened on the same day, but thereafter, my lord, the process of accepting the price bid took place. My lord, 12/6, a letter is written to me for finding justification, also to CMPDIL. On 13th, I reduced the price. Another letter is sent to CMPDIL to justify whether the price is right, reasonable. And thereafter, CMPDL replied, because that is what is the averment in the counter affidavit is, that they justified and found it reasonable.
But probably that communication is not there.
The communication is not on it. That I cannot say, because that, my lord, my friend will have to. But they accepted, and in my submission, they have not controverted that paragraph at page 23 of the counter. So, and thereafter, my lord, the matter kept pending, and then the acceptance was made only after your lordship, Lord, the earlier judgment was rendered by this honorable court on 1912, and on 28/12, the letter of acceptance was given for that reduced price. So the acceptance of the price bid did not happen on the same day, my lord. I must make that clear. And now, if lordships, just over the page, internal page 32.
Mr. Kumar, your note.
Sorry, my lord.
Your note
Yes.
mentioned that PDL found the revised quoted price as reasonable and viable.
Is based on that paragraph 20, page 23 of the counter of MCL. That is why, my lord, as I submitted earlier, most of my dates have come from the writ petition and the counter affidavit of the MCL. My lord.
Yes.
At page 108. Let's say 108. How to be right?
Yes. Annexure KD at 108, my lord, is the letter which was written on 13/6 to CMPDIL, and they replied to it. And why I have only placed from the counter, my lord. I have placed that already.
Yes.
Lordship, please. So I am reading, my lord, at page 32, internal page 32 of this selection of bidder part.
Yes.
No, my lord, just on this price, that one of the arguments is that my price was lesser and you should have accepted, and although it was never opened. So the clause 3.8.2a says it need not be opened if you are not technically qualified. But yet, my lord, I am just pointing out in 3.9.2,
Yes.
the authority does not bind itself to accept the lowest bid.
There was no bid.
No, so there was no other bid and it was never opened. But my friend is today arguing, no, my lord, 6,000 crores and 3,000 crores. Mr. Sethi argued 3,000 crores. Mr. Vikas Singh made it 6,500 crores. I have both the arguments, my lord, noted in my file, that the difference was 3,000 crores and then 6,500 crores what came yesterday. So I am only saying that the authority does not bind itself to accept the lowest bid. Is mentioned here.
No, this clause has no application in this case.
Please, I bow down, my lord. I bow down, but since it has been, my lord, I have to address their argument, therefore I'm. And then 3.9.5, bidders are advised that assessment of qualification of bidders will be entirely at the discretion of the authority.
Yes.
That is also mentioned, my lord, clearly.
Yes.
And under 3.9.4, I was required to give performance bank guarantee, which I have completed, my lord. But that's a subsequent event, my lord. So and now, my lord, I think your lordship will rise for
After
lunch.
We will continue.
I will take, my lord, I have to just show 3-4 more clauses and 3-4 judgments.
Not only one thing I want to point out. One of the main case in our writ petition is that we were considered in earlier tenders, notwithstanding our being as part of SPV. So Mr. Raju, Mr. Nataraj in the morning yesterday said that we may have made a mistake. I want to show, Lord, I've come to know, I've done this research, I want to put it on affidavit, that the successful bidder, that is Mr. Ranjit Kumar's client, is also in a SPV with one DBL of 2018. And he has been, that mistake of Coal India has been done 10 times for him also. 10 times he has been considered in bids. I want to place those bids on record.
We'll hear you, Mr. After he concludes.
No, I have no difficulty. I only want this to be placed, taken on record, because there are two things I want to place. One is my learned friend has an objection, rightly so, that Mr. Sethi said 3,000 crore, I made it 6,000 crore, I gave your lordships a chart. I want to put that on record. And this 10 bids where they have participated and they have been considered. And in 3 cases, they are also declared L1. So it's mistake which is continuing for them also, for us also. It is something which is, so that can be taken on record.
But if it's taken on record, I will need time to respond to it.
No, taken or means, are you filing affidavit?
I'm filing on affidavit because otherwise it can't be blood. This is a matter which, whatever your lordships do, blood will not stop here. This will go to Supreme Court, whether we win or they win.
Don't say this thing here.
No, that's a
Not in
stark,
the courtroom, before the bench.
that's a stark reality. This is from their website, not from the Coal India website. All this is obtained from the Coal India website.
Whatever it may be, my lord, if it is being placed on affidavit, I will need to examine, my lord. I will take instruction from my client.
I
will respond.
didn't want that objection to come post lunch. That is why, Lord, I said that I don't mind giving them, not them, Lord, really, they are not interested parties for this
All right,
affidavit.
let him
MCL
conclude. Mr. Singh, let him conclude
Very
his
well, very
submissions
well.
in the second
Because
half.
it's only MCL, if at all, Lord, response will be required, it will be from MCL, not from them. They will not be privy to
If you
this.
have to file any affidavit,
Yes.
and for that purpose, the matter is to be adjourned, then you will be filing the affidavit in the registry. That will, you will hand over a copy to him.
Very well, very well.
So in the second half,
I'll get it filed in the lunchtime, Lord, and your lordship. We'll continue with it. There's no difficulty. This is only a small.
You'll be filing that affidavit, but is that SPV continuing or?
That is SP is continuing. That SP is continuing.
There are many skeletons, my lord.
So there are
skeletons.
skeletons, because we are also getting, Lord, educated by their argument. That this is a mistake we committed. Anyway, we have now corrected.
No,
That SPV is
I
not
have
there.
not
In
made
our
the
case,
same about any mistake, my lord.
anyway,
No, you are the third party. Why
Yeah,
would-
so
you are not concerned with this.
MCL will consider.
FCL will consider this.
and MCL will also respond, my lord. My friend will have to respond.
But may I pardon to mention a small prayer, my lord.
is the matter very urgent?
Yes.
Regarding
Content
what?
matter because they have highlighted and the petitions are.
Regarding what?
Your lordships remembers that judgment with regard to ACF to promoted as DCF. That matter, they are not doing anything.
So what have you?
Government is not doing it.
No, what have you filed?
Contempt, your lords. Contempt application.
Contempt is not urgent.
My lords.
Contempt is not that urgent.
No,
Contempt
your lordship, I'll tell your lords. Let it be taken up on
Make
Monday.
a Monday.
Monday,
just
yours.
make a-
I don't today, Monday.
Tuesday, Mr. Tuesday.
My lord, I may
Because on Monday, I'll not be available in the first half. Tuesday.
35 your lords, item number 35.
Item number 4, my lord. Negotiation between the parties is going on. My learned friend is there, my lord. They have issued a letter on 5th, day before yesterday, my lord, that we will be sitting and finalize the matter. So I humbly pray your lordship that this matter may be adjourned by 2 weeks. Item
Mr.
number 4, my lord.
Mr. Jana, why should we keep this matter pending? It's pending since 20 years. Whenever it is listed, both of you say it is negotiation is going on. Finish the negotiation or we'll finish the case.
Lord, in fact, my lord, we are seeking your lordship, my lord. I am for HPCL in this matter, my lord. Complete lack of cooperation many a time from the petitioner, my lord. Therefore, the matter is getting delayed.
We'll dispose of the application. Every 1 month, the same submission, that negotiation going on.
My lord.
We'll see later.
Your lordship may take it to 4 weeks after.
No.
In the meantime, if no
Sorry.
result will come out.
Sorry. Will come on Tuesday.
My lord,
It will come on Tuesday.
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 My lord.
Thursday.
Thursday.
My lord.
Thursday.
My lord.
Lordship has posted the matter to Thursday, my lord.
Content matter, my lord. 2625 2020.
ଏଇଠି ଗୋଟେ ମ୍ୟାଟର ଚାଲିଛି ସେଥିପାଇଁ ଆପଣଙ୍କର ଆଜି ଆସିଥିଲେ ବି କେସ୍ ପଡି ନଥାନ୍ତା ସେଥିପାଇଁ କଲା କରାହେଇନି ସେ
My lord, can you give me
ସେଇଟା କାଲି ହଁ ଆପଣଙ୍କର 22 ତାରିଖ ଆସିବ କାହିଁକି ନା ସେଟା ଶୁକ୍ରବାର କେସ୍ ଆଉ 15 ତାରିଖ ଛୁଟି ଅଛି ସୋ 22 ତାରିଖ ଆସିବ ଏ ସାରଙ୍କ କୋର୍ଟରେ ଏଠି ଆସିବ
My lord, I'm sorry. Item 4, your lordship has posted to next Thursday.
yes
Yes. Thank you. Very well. Fine. Deeply obliged.
Wait, please, Your Lordship. So, my lord, I'm just completing the RFP, my lord, on an interpretation of them. So, my lord, if your lordship will kindly come to internal page 34, this is writ petition 17120,
Yes.
annexure 7. And I am requesting your lordships to have now page 119, internal page 34, running page 119 of the writ petition.
Yes. Yes.
May I place it, my lord?
Please.
Because this is one of the clauses given in the rejection letter. The bidders and their respective officers, employees, and advisors shall observe the highest standard of ethics during the bidding process, notwithstanding anything to the contrary contained herein. The authority may reject a bid without being liable in any manner whatsoever to the bidder if it determines that the bidder has directly or indirectly or through an agent engaged in corrupt practice, fraudulent practice, coercive practice, undesirable practice, or restrictive practice in the bidding process. Now, my lord, at the foot of the page, last two lines, undesirable practice is defined. Because 4.3 says, for the purposes of this clause 4, the following terms shall have the meaning hereinafter respectively assigned to them. Undesirable practice means one we can skip, my lord, over the page if your lordship see 2, having a conflict of interest. So, the rejection, my lord, is in under 2.2.1b, read with section clause 4.1. And that's what the letter itself says in the rejection, which your lordship will find.
Yes.
At page 51 of this very paper book, annexure 3,
Annexure 3.
annexure 3, page 51 of the writ petition,
Yes.
in the middle, my lord, after the name of my client, my lord, the bids of the following 2 bidders have been disqualified having conflict of interest as per clause number 2.2.1b or of the RFB declaration under point 5 of bidders covering letter and acceptance of bid conditions under 2.6. Your lordship will recall at place 2.6 for the purpose that acknowledgement by bidder, that by submitting the bid, he is acknowledged that he does not have conflict of interest. So that's the second one. And rejected under clause 4.1 of RAB due to directly or indirectly engage in undesirable practice as defined in clause 4.3d, which is what I placed today just now. And then the names of the 2 bidders are mentioned below it.
Yes.
So, my lord, and then, my lord, your lordship may just permit me to show one more thing, and that is, my lord, page 122, internal page 37 of that annexure 7. I'm taking your lordship back. This was only for completeness, my lord. I took your lordship back to annexure 3, my lord. Annexure 7, running page 122 in that RFP, internal page 37.
Yes.
My lord, your lordship will see this is miscellaneous. And then 6.2 under this section, the authority in its sole discretion and without incurring any obligation or liability reserves the right to at any time to consult with any bidder in order to receive clarification or further information. C, qualify or disqualify any bidder. E, independently verify, disqualify, reject, and or accept any or all submissions or other information or evidence submitted by or on behalf of any bidder. So this power, my lord, the authority is vested with. Now, my lord, three things, my lord. The clause, sorry. So just to sum up this part of the argument, my lord, is that the basis on which the bids of my learned friend clients was rejected is apparent from the very interpretation which is provided in the clauses on its plain reading. We don't need to go anywhere else. And if on that plain reading your lordships come to that conclusion and uphold the decision of 12-member committee who went into that technical qualification of my learned friend client based on documents submitted by them as work certificates, work experience, then, my lord, nothing more is required to be gone into beyond that. And my lord, the Chief Justice, my lord, yesterday, very pithily, my lord, put the issue, which I have, my lord, written it as yesterday, that the entire issue is whether any conflict of interest as per the technical evaluation is right or wrong. This is the crux of the, Lord, in my respectful statement, all humility, my lord, I am quoting my lord, and lordship will forgive me for that. So that is so on an interpretation. Now, the case law that has been referred to does not show in any way that your lordships will substitute an interpretation which either my learned friend want or what your lordships would like that would be a better interpretation in the face of this plain reading. That's how, my lord, the judgments have evolved over a period of time. So if on a plain reading, a decision of an expert body of a 12-member committee having come to a conclusion that this is the way I have understood, then that ought to be upheld, my lord, is my respectful submission. Now, my lord, this clause of conflict of interest is not of new, my lord, origin. It has a vintage, and I'll place a few decisions, my lord, on that it is not something which has happened new, my lord. May I just pass on a compilation of, my lord, judgments, my lord.
Yes.
My lord, I am requesting first your lordship to take this judgment, which is at page 188 of this compilation, the Delhi High Court judgment, rendered way back in 2009, where this almost identical clause, similar, of course, my lord, was in issue. My lords have page 188.
Yes.
May I place it, my lord? This is also, my lord, with respect to, my lord, if your lordships come to page 189, the people who had come for the evaluation first, my lord, shortlisting of candidates, this was on shortlisting, kindly come to para E, my lord, at page 189. The duly constituted evaluation committee of the NHI evaluated the application submitted by all the 23 applicants, and on the basis of evaluation, the NHI shortlisted the following 6 applicants. Now, my lord, number 1 is the petitioner in this writ petition, and number 5 is with whom they had some 8% shareholding. So, my lord, after this shortlisting, my lord, what has happened is that the bids were submitted, etc. And kindly come to page 190, running page. Clause 1, my lord, para small Roman 1 says, here it is relevant to note that both the RFQ as well as the RFP contained a clause pertaining to conflict of interest. The RFQ document in clause 2.2 provided for eligibility of applicants. Clause 2.2.1c defined conflict of interest as follows. An applicant shall not have conflict of interest that affects the bidding process. Exactly the same thing, my lord, if your lordship were to compare with 2.2.1b. Any applicant found to have conflict of interest shall be disqualified. Exactly the same. First two sentences. Now, my lord, the deeming provision with that those who will be considered as deemed conflict, an applicant shall be deemed to have conflict of interest that affects the bidding process if the applicant is member or associate or any constituent, and any other applicant, member, associate or constituent have common controlling shareholders or other ownership interest. Then the proviso says, not apply where the direct or indirect shareholding of the applicant in member so and so in member is less than 1%. There it was
identical.
1%.
Almost identical, except that
almost identical. Please, Lord. And then, my lord, 2 also is the same as constituent of one applicant is also the constituent of the other. And then 5 also is the same. Such applicant has a relationship with another applicant directly or through common third parties that puts either in both of them in a position to have access to each other's information. Now, my lord, after this quotation, my lord, I am just at page number 191, I am just reading those 4 lines. All the applicants at the RFQ stage are also had to submit before the NHI an undertaking as prescribed in Appendix 1 to the RFQ in terms of the said requirement. Petitioner submitted an undertaking before the NHI stating that the petitioner did not have any conflict of interest. Same thing as what has happened here, that in 2.6 there is an acknowledgement that by submitting the bid document you don't have conflict of interest. And then, my lord, the RFP document also had the same clause, 2.1.4, contained a similar provision pertaining to conflict of interest. My lord, I am skipping this because it's the same thing, almost repeat. Now, my lord, if your lordship now see at 192 after the quotation, after number 6, all the shortlisted bidders were required in terms of the RFP to submit another undertaking as contained in Appendix 1 to the RFP document, wherein the bidder had to declare that they did not have any conflict of interest in accordance with clause 2.1.4 and 2.1.5. In terms of the above requirement, even the petitioner submitted an undertaking that it did not have any conflict of interest. Then before that, my lord, there is some correspondence, etc., which I don't want to get into, my lord. But one of the letters that was written by the petitioner was that this conflict of interest clause should be modified after having submitted the bid, etc. But I am skipping all that. And if your lordships come to page number 194, the very argument which my friends are making in paragraph 3 of the judgment. May I place this, my lord? 194, para 3. Mr. So-and-so, appearing on behalf of made the following. His first submission was that the condition with regard to conflict of interest had been waived since the petitioner had already been shortlisted. Second submission was that the conditions stipulated in RFQ and RFP are not mandatory and that the same should be read down so as to be read pragmatically. Third submission was that the petitioner at the time of applying for the request for qualification was not aware of the fact that Albertis, which held 6.68 shares in Atlanta, the petitioner's partner was one of the members of the consortium that had also applied in response to the RFQ. My friend made that argument just now. Further, it was contended by the petitioner that the principles of natural justice had not been followed by the NHI, inasmuch as the petitioner had not been informed of its disqualification prior to the remaining bidders being called to participate in the second round of bidding. And the last submission was that since the consortium of which Albertis was a constituent did not participate in the second stage, did not submit its financial bid, therefore petitioner consortium did not incur any disqualification. This is the argument below. Now, if your lordship will kindly come to para 5, my lord, extracts the appendix 1 to the letter regarding to be given for the clauses by the person who is applying. And if your lordship see the bold portion at 196, I declare that we do not have any conflict of interest in accordance with so and so. And at 198 again, my lord, the same thing is mentioned. I don't need to, my lord, just repetition. So it's all about conflict of interest. Your lordships may now straight away come to page 203, para 6. The judgments, my lord, are considered, the precedents are considered by the Delhi High Court in para 6, my lord, onwards. And my lord, I am not repeating any of these because, my lord, most of the arguments, most of that has been already shown. But I would request your lordship to kindly come to 205, the bold portion extracted from the judgment of 2001 to SEC. This is West Bengal State Electricity Board. Sorry, your ladyship. Very sorry.
Yes. Please continue.
Please, Lord. This is 205, page 205 of the compilation. The bold portion, my lord, I am requesting your lordship to, my lord, kindly have a.
Yeah.
It is essential to maintain the sanctity and integrity of process of tender bid and also award of a contract. The appellant, respondent 1 to 4 and respondent 10, 11 are all bound by the instruction to bidders, which should be complied with scrupulously. In a work of this nature and magnitude where bidders who fulfill pre-qualification alone are invited to bid, adherence to the instruction cannot be given a go-by by branding it as a pedantic approach. That pragmatic and pedantic. Otherwise, it will encourage and provide scope for discrimination, arbitrariness, and favoritism, which are totally opposed to the rule of law and our constitutional values. The very purpose of issuing rules instruction is to ensure their enforcement, lest the rule of law should be a casualty. Relaxation or waiver of a rule or condition, unless so provided under the ITB by the state or its agencies, in favor of one bidder would create justifiable doubts in the minds of other bidders, would impair the rule of transparency and fairness and provide room for manipulation to suit the whims of the state agencies in picking and choosing a bidder for awarding contracts as in the case of distributing bounty or charity. In our view, approach should always be avoided. Where power to relax or waive a rule or condition exists and the rule, it has to be done strictly. We have therefore no hesitation in concluding that adherence to the instruction to bidder or rules is the best principle to be followed, which is also in the public interest. Now, my lord, this sentence above, my lord, about favor of one bidder or versus the other, what Justice Bela Trivedi said in her judgment in Bansidhar is the same thing, that you gave an opportunity to fulfill the documents. There were the finance audit documents were allowed to be completed 4 months later. So the honorable judges held that you did not, for the purpose of the other person who was the petitioner, the power of attorney, which was given already, was only notarized 1 day later. You did not accept and you did not ask anything. And on the other hand, where you to fulfill the documents in the other case, you asked the person to supply it later and awarded the contract. That is the judgment of Justice Bela Trivedi. That is the clear distinction, my lord, in that case. Now, my lord, Asia Foundation, I am skipping, my lord. Kindly come to para 7 now at 207. In the RFQ, provided for conflict of interest clause, that is clause so and so, whereby it was postulated that any applicant having a cross holding with another applicant or its consortium partners in excess of 1% was disqualified from participating. It is an admitted position that Albertis, a constituent of the IDFC-led consortium, has a 6.68 shareholding in Atlantia, the consortium partner of the petitioner. So, my lord, look at how this shareholding is being considered of two consortiums. for the purpose of the also applicants were to satisfy themselves that they were qualified to bid and were required to give an undertaking in the form of appendix. The undertaking in compliance of Appendix 1 was furnished by the petitioner as well as consortium comprising Albertis. The undertaking in Appendix 1 is so furnished, clearly provided to the effect that petitioner did not have a conflict of interest. It is further seen that in case of any change in facts or circumstances during the bidding process, if any disqualification in terms of the guidelines was incurred, the petitioner would intimate. It was on the basis that this undertaking that NHAI shortlisted the applicant as per the provisions of the RFQ document. So, my lord, here all three, one of the argument was we all three were found to be capable of being evaluated for technical. So you have shortlisted me. Now you can't oust me. On that, my lord, this is the answer to that. That if you are not found qualified thereafter, the question of only shortlisting doesn't take care of it. The NHAI by its letter, sorry.
What do you mean by shortlisting?
Shortlisting that three bidders came forward for the purpose and three were put up for shortlisted for the purpose of techno-commercial evaluation.
So shortlisting, whosoever applied was shortlisted.
Yes, my lord. No, even at that stage, supposing, my lord, somebody did not give any undertaking or somebody did not fill up something, they could have been out, my lord. So the shortlisting is to that in that sense, my lord.
Yes.
It was on this basis of that NHAI shortlisted. NHAI by its letter shortlisting both the petitioner as well as the consortium comprising the said Albert clearly provided participation in the stage of bidding process was subject to continuing compliance to various provisions of the RFQ, as well as provided that provisions of RFQ would apply mutatis mutandis to the shortlisting announcement and subsequent bidding. Therefore, we find no merit in the submission, my lord. And then para 11, I need to place a few lines, my lord. Second sentence in para 11. Even otherwise, there could be no waiver in view of the provisions of clause 2.6.4, which clearly stipulated that failure to undertake verification of all statements, information, and documents submitted by the bidder would not relieve the bidder of its obligation or liabilities under the terms and conditions of the tender. And the next paragraph, my lord, the submission on behalf of the petitioner that they did not know that Albertis, which had a cross-holding of more than 1% with the partner, were to participate in the bid is untenable and also does not hold any water. Conflict of interest and cross-holding are matter of fact, and it had nothing to do with whether the applicant participated in the tender deliberately or inadvertently. In other words, knowledge of the participation was irrelevant. What was relevant was that Albertis had a 6.68% shareholding, the consortium partner of the petitioner, which in fact had not been disputed by the petitioner itself. Then, my lord, the last para on that page 14 about the natural justice, my lord. Fourth line of that. Insofar as the submission with regard to NHI not having followed the principles of natural justice in disqualifying the petitioner is concerned, suffice to observe that under the provisions of RFQ as well as RFP, the NHI could forthwith disqualify an applicant or a bidder at any time upon discovery or uncovering of any material misrepresentation or violation of any condition stipulated by the RFQ or RFP. Even otherwise, in the present case, before the NHI could seek an explanation in this respect, petitioner, based on the representation of other bidders, wrote a letter to clarifying its stand in that regard. Now, my lord, para 16. Lastly, on behalf of the petitioner, it was urged that the stipulation contained in the tender ought to be read pragmatically and consequently read down. In this behalf, it would serve us well as remember the observations made in West Bengal at City Board, my lord, the same thing, my lord, which I have already placed before, my lord. So all the points, my lord, have been answered here, and in my respectful submission, my lord, they apply equally here in our case, my lord. The other judgment, my lord, which is on this in this very volume, my lord, at 211, also of the Delhi High Court, is about a tender by the Power Finance Corporation, my lord, and this cross-holding.
Yes.
Your Lordship will kindly come to at page number, my Lord, I'm skipping the facts, my Lord, so I don't want to I'll take your Lordships immediately to para 11, my Lord. The petitioner was called upon to clarify the relationship between the petitioner, IGL1, SPGVL, and IGT, along with documentary evidence to prove that there was no conflict of interest between so and so. And thereafter, my Lord, your Lordship may come to the arguments are in para 19 and goes up to 25. Thereafter, the counter affidavit is considered, and your Lordship may straight away come to para 33 at page 216. The grounds for rejection by the committee against the petitioner are as under. As per the definition of RFQ, conflict of interest, a bidder shall be considered to be in conflict of interest with one or more bidders in same bidding process if they have a relationship with each other directly or through company that puts them in a position to have access to information. Same clause as number 5 here in ours. So this so and so, my Lord, I am not going to that fact. So and so had. Thereafter, the board of respondent number 2, that Power Financial, took cognizance, etc., and took a decision. Then, my Lord, the document is mentioned, and the analysis starts from para 39 at page 217. The short point that arises for our consideration is whether the reasoning adopted by BEC and subsequently confirmed by respondent number 2 for disqualifying the petitioner on the ground of there being a conflict of interest between two bidders, that is so and is reasonable and rational based on irrelevant consideration information provided by the parties and not hit by malified arbitrariness and the Wednesbury principle. Then, my Lord, RFQ is some portions are quoted below 2.1.5. Then conflict of interest is in clause 3 over the page, my Lord, at 218. And then para 4. On the basis of the information provided by the petitioner, respondents have graphically depicted the inter se relationship between the petitioner and corporate entities. This is what the counter affidavit of the Mahanadi Coalfield also does. There is no dispute raised by the petitioner to the said tabulation insofar as the structure relationship is depicted. Lord, I am skipping this part, that the tabulation is there. And then para 7, my Lord. Para 6 and 7 and 219. Clause 2.1.5 categorically states that in the event of conflict of interest, the bids of the bidders shall be rejected. The bid of the petitioner has been rejected due to conflict of interest. Conflict of interest as conceptualized in the RFQ is wide and encompassing. The key words used in the conflict of interest clause are relationship with each other, which is what I had emphasized, my Lord, in my respectful submission. And that puts them in a position to have access to information about. The scope of judicial scrutiny in disputes arising out of rejection, award, or public tender is limited. We cannot examine the decision on its merits. We are primarily concerned with the decision-making process. Thus, we are only to see whether the decision of BEC as affirmed by the respondent is reasonable, non-arbitrary, and if malifieds are alleged, whether the same is malified. Thus, we need to examine whether the decision of respondent to invoke so and so is plausible and reasonable. It is then, if it is, then no interference would be called for. Then, my Lord, facts are gone into, and then your Lordship may come straight away to paragraph 12, the question that was raised by the petitioner's counsel, my Lord. So and so for the petitioner raised twin questions before us. Whether in case of common directors in two corporate entities, flow of information of one company to the other company can be imputed. That's one thing, my Lord, here. And then, my Lord, whether any information had been disclosed between the two companies in question, that is the petitioner and IGL. And then judgments, my Lord, are extracted. And then your Lordship will kindly come to para 17. Reliance placed by Mr. Kripal on the aforesaid decision is misdirected and misplaced. This is for the reason that the benchmark for the existence of conflict of interest in terms of the definition contained in RFQ is not that the two bidders must, as a matter of fact, have shared, exchanged the relevant commercial information. This is what I'm, and then, my lord, your lordships may skip all this, because what is being highlighted there is that puts them in a position to have access to have information. Now, my lord, kindly come after quoting the Calcutta High Court judgment, etc., my lord. And AFCONS is quoted, referred to, my lord, in para 19, not quoted, my lord. Para 20 now. We have examined the decision-making process undertaken by the respondent. Various letters were exchanged between so and so to be able to acquire the relevant information for the purpose of examination and decision. BEC had also sought legal opinion from so and so. As so and so had provided detailed opinion. Deliberate process had culminated into the finding that common director puts the petitioner and so in a position of access to information. For the purpose of RFQ, it was necessary to determine whether relationship between two companies puts them in a position to have access about or influence the bid, having a common director as the non-executive so and also managing director of so and so. Indeed, puts both the companies in a position to access information. It is important to reiterate that the respondent was not called upon to examine the situation at hand with a microscopic lens and determine whether, as a matter of fact, information was exchanged. All that the respondent was required to examine was whether the two companies were in a position so as to have access to information of the other company with regard to their bids. In the light of the discussion, we are of the view that conclusion drawn by the respondent, both the companies were in a position to access information, was reasonable, well informed, and justified.
Yes.
So, my lord, insofar as the other decisions, my lord, which we have put in our compilation, Lord, just to respectfully submit, my lord, that we have mentioned the para numbers, my lord, there, and they are only reiterating what has already been, my lord, placed before my lords. So instead of wasting, my lord, any further time on my side, my lord, and multiplying documents, decisions, my lord, the only thing that is missing there, my lord, is that care tell of Justice Call judgment in 2019, which was quoted, my lord, in that judgment of UFlex. Your lordship, when I read that part of the, so I will give a handover a copy of that judgment as well, my lord, for your lordship's kind consideration. And paragraphs 37 to 42 may be kindly, 43 here. In this judgment, my lord, paras 37 to 43 of 2019-14 SCC, page 81, which is a part of reference in the relied upon in the UFlex judgment. So, lordship may just note the para numbers, my lord, if I may request your lordships to kindly, my lord.
Which paragraph?
Paragraphs 37 to 43. Now, my lord, I have also, my lord, prepared a list of submissions, written submission. If I may pass it on, my lord, please. I will just read a few paragraphs, your lordship will permit me. Just a few minutes. So, my lord, this part about my lord, MCL at the tending are rightly disqualified. I don't need to, my lord, I have explained. In my lord, and then over the page we have it dealt with in extenso. And at page, my lord, 4 is regarding MCL in its sole discretion can disqualify. And my lord, we have also quoted the relevant clauses. Then, my lord, C, my lord, at 5 is this court under writ jurisdiction ought not to interfere with MCL decision to disqualify. And at page 6, my lord, in submission D, regarding me, my lord, that I am an eligible bidder under the RFP. And at page 7 at the foot, my lord, number E, MCL has rightly allowed the variation of VPR price bid, which is reasonable as per the market standards. And then F at page 9, this is all the subsequent events, my lord. I understand that your lordship's interim order said that everything will be subject to the decision in the writ petition, but we have put it here, my lord, what all we have done. So, my lord, that is in good faith made substantial investment of money, capital, labor, resources for the execution. And it will be in contrary to public interest, my lord, at this stage to interfere, my lord. Is my respectful submission, my lord. I am very obliged. The lordships have been very gracious enough to give me time, my lord, to present the case before my lord, my lord. My first opportunity, my lord, before my lord, my lord.
No, it's not your first opportunity.
Lord, I have served them the affidavit.
Mr.
So
Ranjit Kumar is forgetting. You were appearing when I was in Patna. That COVID.
In that three judge,
No, that COVID.
on virtual,
Yeah.
my lord. Please, my apologies, my lord. My apologies. Yes, my lord. Yes. During
Physically
COVID.
first time, yes.
Yes, my lord. I'm please forgive my,
Yes.
my lord. I'm getting old, my lord.
Yes.
I can only say that I'm getting old.
Yes.
just
I'm very, very obliged.
I admire my memory for it being short.
No, my lord. Please,
your lordship have shown memory which
Please.
didn't have.
please, my lord. Much obliged. Very great.
And I've served the affidavit, Lord. Obviously, he doesn't have to say it. Because there, it is there.
I haven't seen it
It
yet.
is there.
So,
No, it has been served upon you.
no, so maybe. So I'm not saying that
Just.
you would have given one copy. We'll make copy. Then we'll see.
I appear in the connected case. Along with my friend, I appeared. But I don't want to burden your lordship with because I adopt all the submissions made by Solicitor General as well
And
as
not, by Mr.
Uh,
Mitraj.
Mr. Kumar also. That's just one thing I just want to add. Because your lordship knows the price bid, they have substantially submitted before your lordship that why the price is not so important because that I am not repeating. But let us take for a moment, because every time it is being said that there is a loss of 3,000 crores, then again escalated to 6,500 crores and there's a loss of public revenue. But whether it is a fact or not. But my submission would be that our clients, by our reduction, the MCL has been saved of 1,000 crore rupees. But why I say just that point, I will explain. Your lordship sees that
But
vigilance.
they also want to save more rather.
No, I don't want to say. I don't want to repeat the arguments which have been stated. I adopt them. So, that Coal India, that vigilance guideline, contract management manual, which they gave. Your lordship will just see that for a moment again. Just few lines, 4 lines I will place there. Because I think that is in our support. Your lordship may see that.
Yes.
Rejection of a single bid.
Yeah.
Lordship got it. Rejection of it. It has become a practice among some procuring entities to routinely assume that open tenders which result in single bids are not acceptable and to go for retender as a safe course of action. This is not correct. The guideline says the opposite. Rebidding has cost, firstly to the actual cost of retenders, secondly the delay in executing the work with consequent delay in the attainment of purpose for which the procurement is being done, and thirdly the possibility of rebid may result in. That means, first of all, at the outset, the guidelines which they rely, they discourage that you should not throw away a single bid outright. What is the exception there? Lack of competition shall not be determined solely on the basis of number of bidders. Even only when one bid is submitted, the process should be considered valid provided the following conditions. They relied on that. Now let us go one by one. The procurement was satisfactorily advertised and sufficient time was given for submission. We don't come under this because this is nobody's case. The qualification criteria were not duly restrictive. That your lordships had said yesterday that your lordship, this clause is not being challenged. That it is unduly restrictive is nobody's case. They said that we do not come within the concept of conflict. Therefore, the court had rightly said that conflict of interest has to be decided first. If conflict of interest is there, then other things go to. The third thing is prices are reasonable in comparison to market value. This is the only point remains. Now, so far as this is concerned, in my counter affidavit I have given, I'll place that. In a similar grant, for a similar mining, the price in 2021, was 497 rupees per ton. Now, if we put the escalation scale, it will be on the date of this present year, that will be 597. We have come down to 532. I need not repeat, Lords, because my learned friend has shown to your Lordship that the power is there to negotiate, and 532. In this process, the MCL is saved of 1,000 crores, not about 1,000 crores. Your Lordship may kindly see that part of that one paragraph I'll place. That is 17120, paragraph 5 of my additional counter affidavit after they filed the amendment petition. That is dated 24/6/24.
But this is your submission that pricing is immaterial.
Yes.
The question is
Besides
only of disqualification.
Disqualification.
That is.
No, I just say, even if going one step ahead, it is factually incorrect. It is
Actually,
I'm obliged. I'm obliged. Your Lordships are absolutely correct, because the initial argument is that is immaterial. That is immaterial. But still, then also we have quoted a price well before the bat, because the third sentence says of that guideline.
Think of a situation that if today they say
Yes.
that they are ready at 525.
525. So is it material? So
Therefore, Mr. When you are saying that by quoting this price, you have saved 1,000 crores,
yes,
they may say that they'll save 2,000 crores.
No.
So this is not the stage for us to.
Perhaps not. No, so far as the guideline is concerned, they are saying that it should be reasonable in comparison with material. So what is reasonable in comparison with the market price has been done, and they have accepted. That is what I would do. Not much of it.
How should we proceed further, Mr. Singh?
I would like to place that affidavit first, Lord. So
No, we should not, because you have just filed. That will be, today it is impossible for us to take into account that affidavit which is in the process of filing or must have filed.
It is already
must have been filed. They are yet to go through that affidavit. So either we adjourn the matter for them to consider your additional affidavit.
Only for the short point of responding to the affidavit. Otherwise, Lord, we can conclude the argument. I mean, I'm ready to conclude the short point of responding to the affidavit, which is a factual thing only.
If there is any fact, then they have a right to.
No, I'm down. I bow down. I'm not even trying to suggest.
If there is any additional fact, so you may, if you want, you may conclude your submissions.
What I was suggesting, Lord, subject to your Lordship's pleasure, that I conclude my argument as far as the main matter is concerned. I place that affidavit also for your Lordship's consideration, and then let them respond. And if there is any factual thing which they say this is not correct, let them say whatever they have to say. I have no difficulty on that. Let them be given 2-3 days.
Like legally, you made your submissions covering that also, that aspect.
Yes.
It's only that you brought up a case
I got 10 more people. That's right. I've already covered. It's only a factual inquiry, because yesterday an argument was done by mistake. So I wanted to say how many times you make that mistake is all that I'm trying to emphasize on. That it is something which is, and one more thing, Lord, actually.
No, what is that mistake?
No, Mr. Nataraj said that if we considered them notwithstanding the SPV, it was a mistake. And we can't enforce negative equality. We can't say that same mistake be perpetuated. That's what the argument was. I'm saying that this mistake has been.
What he was submitting, that only because an incorrect decision was taken in one of the tender processes, therefore they are duty bound to do that in the present tender process.
I am bound on this. That's exactly what I'm submitting. So I'm saying that mistake, what he's alleged that it could have been a mistake, and we are not obliged to do that mistake again, and a writ court will never ask for enforcing negative equality. I am saying that mistake has been done in 10 other cases where the successful tenderer also is involved. where when Pachwara was given, there were two areas in Pachwara where MDOs were appointed. One area is where that Pachwara of this SPV between me and BGR is there, where I am 51 and 49. The other area went to this other SPV, where the petitioner, the successful bidder before your lordships, and one DBL was a joint venture constituent. And they ultimately formed the SPV, which is in 2018.
Should we go into those aspects?
I'll tell you lordship why. In fact, now, really speaking, this writ can be allowed today itself. Mr. Ranjit Kumar, when he, in response to my, that later clarification which has come, that note which has come, Lord, in that Coal India, as far as CCL, subsequent, he says it's a clarificatory, it is only explaining what is the earlier position. If it is clarificatory, then this bar was never there. Your lordship knows the effect of a clarificatory note. A clarificatory note goes back. He also admitted that it goes back. It applied from before also. It's just a clarification. If it's a clarificatory note, then this qualification was, this conflict of interest is already explained that this is not a conflict of interest.
There is difference between reading provisions of a statute and.
No, his argument, I'm on his argument. He made the statement that this is a note which is a clarificatory note. So what I will suggest, not that.
I think my friend, if I may interrupt my friend, what I said was that this note, which is making clear, shows that now this is the position what they are considering.
Now my friend is wanting to resign.
No, I'm not going anywhere.
He would want to, but
anyway,
but he had said that.
Let us first of all decide how to proceed.
If my friend is going to place those documents, my lord, then we will need time. If my friend wants to otherwise conclude without reference to those documents, there is no problem.
I'm subject to what your lordship, Lord permit. My request would be that your lordships have heard everything is fresh in your lordship's mind. Let me conclude this part of argument. That is only an additional feature which your lordships will consider whether your lordship want an affidavit. If they want an affidavit, I can't deny that right to them. It is definitely to be given to them because this is not an issue which will, whoever wins this matter has to go. So
Mr. Vikas, please don't repeat that. You do whatever you want to do. See, we must explain.
I will say I will win and they will go. I don't want your lordships to face any
When we write judgments, we don't keep this in our minds.
I know, obviously.
That there is some
never. No,
and how this will be.
No, by endeavor.
How your lordship judgment will be judged is never in the mind of the judge.
It should never be.
No,
never.
I'm sorry.
It should never be.
I'm sorry if I
never
kept that
be
Never
in the mind of even a munsif.
No,
He should also write his judgment as if
absolutely.
he is the final authority on that.
I'm sorry if I gave that impression. I didn't mean that at all. What I meant was something else. What I meant was that this is a fact, Lord, which we have discovered because of Lord this inquiry, because of their argument. Because according to us, and this is a job, Lord, even the Bar Council says, Lord, every lawyer is supposed to give all facts to the court. This fact should have come from MCL, ideally, that we have done this mistake in so many cases, but nevertheless don't consider this at all. So they should have referred to these. I referred to 2 cases. They say it was a mistake, don't follow. Now I said 10 more cases. So they say these are consistently followed mistake. And now if there is a note which explains that this is actually not a mistake, then really speaking, the writ can be allowed. So the purpose why I'm saying...
So better course would be, Mr. Singh, that we adjourn the matter. Let them consider your additional.
Lord, why only I'm requesting, Lord, that your lordship may hear me only for simple reason, Lord.
Yes,
I don't want the argument to start de novo.
All right.
Only for
yes.
motion can go, and only for the purposes of that, those 2 affidavits your lordship can keep it already.
Just one thing I would like to add. With the permission of the court and Mr. Singh, I'm sorry to interrupt you.
Mr. Nataraj, let us.
Yes.
Today, let us don't enter into whatever comment. I can understand what you are going to say, Mr. Nataraj. But
that's not. I wanted to point out only one thing because he has been repeatedly saying that
we do understand.
I never said it was.
Yes, please.
Yes, I never said it was a mistake. I said that in that particular document, whatever has been furnished, based upon that decision was taken.
All right.
Alternatively, by assuming that there are certain other clauses and there is some kind of mistake, that will not confer right. And he cannot take it that it's a mistake.
All right. All right.
Yes.
Yes.
So, Lord, so just to conclude this part of whatever has been argued, that part only, because I still have about 1 hour's time, I can do that.
No, we have enough time.
Yes. So, Lord, one thing again, Lord, which I have argued strenuously and tried to impress upon your Lordship, because your Lordship very rightly put to me at the very outset, that whether I qualify on a plain reading of the conflict clause or not. If I don't qualify, I don't qualify. I can't ask your Lordships to read down, as Mr. Rohgi wanted the High Court to do in that other matter, which was decided in that case against him. Firstly, I have to show that I don't come within the clause straight away. My conflict of interest, if at all, will come with something more which has to be put on record factually, either on the basis of some correspondence or on the basis of some inquiry. The fact that there is a joint venture which is a separate juristic entity because it's a company incorporated. Why this? Let me just explain about why joint venture and why SPV. Whenever there is a contract for 3 years, so there are a lot of contracts which are only to be completed in 2 years and 3 years time. So whenever there is a contract which is only to run for 2 or 3 years, a joint venture is acceptable to Coal India. And whenever the contract goes like ours, not an MDO, which goes for 29 years or 27 years, then they insist that a joint venture is a loose arrangement. Let it be a registered company where both of you are constituents by a certain prescribed shareholding, so that both of you are responsible for the whole of the 29 years. Because then you create a juristic entity. So the purpose of a SPV is only to ensure that it's a long project. A company has got a character which will not change if one director dies or one shareholder sells his share to somebody else. A company will continue being a juristic entity. So SPVs are created whenever there is a long tender. This is what Coal India has been wanting to do, that if it's a tender which has to go for more than 20, 30 or 20, 30 years, between 20 to 30 years, then a JV will not suffice. The bidder can be a consortium. So this is between a joint venture and a SPV, this distinction. A bidder can be a consortium. So these 3 words are coming in repeatedly. Your Lordships are seeing these 3 words. A bidder can be a consortium, meaning that 2 people need to decide that we will
joining together
for the purposes of the bid. This is a consortium is only for the purposes of the bid. When you qualify, if it's a contract for 2 or 3 years, that consortium gets converted into a JV. If your consortium qualifies for a MDO contract like this, which goes to 27, 29 years, then the requirement by the terms of the tender itself are that you will create an SPV. Because SPV has that character of continuity and it's a juristic entity, etc. So these 3 words have to be understood in this context. Consortium is the bidder, which is loosely associated to, they make an agreement that we'll bid together. This why you don't ask for a SPV to be constituted prior to being allocated, because you may get it, you may not get it. You don't want a company to be constituted if you're not a successful bidder. So the requirement of formalizing the consortium status arises after the bid is accepted. So once the bid is accepted, you either go to the SPV route or you go to the JV route. This is how Coal India has been interpreting, and that is why there are some JVs, there are some SPVs. The particular contract which I am placing today in my affidavit on record is a case of an SPV. Earlier case that we have put on record was a case of a JV. So the argument against me was, well, JV we look at differently. That was one argument. The other argument is mistake. JV we look at differently. SPV is different. You have an SPV. JV is acceptable. That is on affidavit. Mr. Nataraj may have said on orally that it is a mistake and we can't enforce negative equality. That may be his argument, but on affidavit, they say that that was a JV and what we have is a SPV, so accordingly, we can't equate the two. That is why this new affidavit of mine is relevant, because here also there is an SPV. And in this SPV, there are 10 instances, 2 by MCL, which is the respondent before your lordships, and 8 by Northern Coalfield Limited, which is also not a subsidiary of Coal India Limited, where the successful bidder before your lordships and one DVL, who are SPV blood constituents in another Pachwara 2. Let me put Pachwara as 2.
I thought my friend will not argue on the new affidavit.
No, I will argue.
Then my lordship may adjourn the matter.
You will have an opportunity to respond. But
No.
This
My
affidavit
friend
will have-
would complete the argument vis-a-vis our arguments on this side. If he wants to argue on that affidavit, keep it on a separate day.
Otherwise,
Well, neither the MCL has it to verify. I have to verify.
This will become an unending process.
Yes.
So either you confine to the materials which are already there on record, or you just have an adjournment.
Ultimately, the argument will be one. I'm not saying the document may have been placed today, but the argument is that whether it be SPV or JV, it's the same. I'm only trying to say that. I'm only trying to bring that only for that limited purpose. Ideally, Lord, they were supposed to do this disclosure. This is not my document.
We don't know. In fact, he has not seen the.
His
client has not seen.
So only for the limited.
No purpose making any comment on that.
Very well. So I'll leave that aside. But actually, it is only to give an explanation or Lord, to give your lordships to understand the whole controversy. This is important only for your lordships to understand the whole controversy. But if your lordship feel that it will be better, let the reply come, then have it on. But give it one day for that. For what we will then finish. Because I'll take about half an hour otherwise only. So would your lordship permit me to do the other part today? Leave this part only.
Yes, leave.
Well, I'll do that. I'll do that. So, my lord, cartel, as I started off by saying, Lord, cartel is to ensure that the prices are controlled. Is the main reason for a conflict of interest. For a conflict of interest to grab a contract, like your lordship pointed, that could also be a conflict of interest that I don't want anybody to come in. That conflict of interest is very different conflict of interest from this conflict of interest, and the two are to be looked at very differently. The second conflict of interest is the HDFC conflict of interest, which I showed to your lordships yesterday, that railway wagons case, where you kept the price low because you didn't want the small manufacturers to come in. That is the other conflict of interest, where Hindustan Development Corporation. In a conflict of interest of the kind which is being dealt with in this case, where prices admittedly are lower by 6,500 crore, which is also in that other affidavit, but I already made that statement yesterday, so I'm only developing on that. Where the prices are coming lower, the first conflict of interest doesn't arise. Of public interest being not subserved because we are wanting market forces to not come in and we are wanting to control the market and keep the prices jacked up. That's what Lord Cartel says in even HDFC, Hindustan Development Corporation also says that. So a normal cartel is to keep the prices at a level which is much higher than the normal price at which it would be available otherwise to a person not wanting to get services or supply of goods. In the second conflict of interest, which applies here, firstly, there is no such allegation that they are some small-time people whom we are wanting to keep out. They are probably bigger than us in terms of the kind of work that they do, etc.
No, this conflict of interest, Mr. Singh, is not a conflict of interest in fact. So here is conflict of interest in terms of the provisions.
So in terms of the provision, I just come to that. I'm just telling that the conflict of interest here cannot be for the purpose of keeping the price high. Here I'm getting a lower price. I'm much lower price. My price is different from the price of Mr. Naidu's client, your lordships, that has already been argued. There is no similarity. They have reduced from 568 to 535. We are already at 434. And we are not some fly-by-night operators. We are already 3 MDO operators in 3 different, which is our experience. 3 places we are on a 27-year contract doing this very same work. So it's not as if we also have about 1 lakh employees indirectly employed and 6,000 employees directly employed under us. So we are also doing a lot of good work in the country. We are also in the part of the national development, nation building exercise. So we are not a fly-by-night operator that we have quoted a low price only to disturb the tender and ultimately we will not be able to succeed. And there are sufficient guarantees to keep us in check as far as our performance is concerned. And it is nobody's case that we are not eligible to qualify, because the thrust of the argument of Mr. Nataraj especially was that I have a choice. I don't want to get work done from you. I will not want to suffer a work by taking you on board and then suffering you for 25 years. That is one of the main thrust of argument. But here there is no question of sufferance for the simple reason that I am working with them in 2 contracts, with Coal India and with West Bengal 1 contract.
No, Mr. Nataraj's submission was something different. His submission was that a decision has been taken. The main submission was that a decision has been taken to disqualify you in terms of that clause, conflict of interest. Now, that decision, while considering
Judicial review.
The
Your lordship,
scope is-
I'll come. That is my next
scope
limit.
The scope is limited.
I appreciate that is going to be my second limit.
So the scope is limited. And while making those submissions, he referred to certain decisions of Supreme Court, which
I will deal each one of them. I'll deal with each one of them. So there is no case of me being a non-performer. Let me put that, because orally it was said. So let me just answer that orally. There is no question of me being a non-performer or any allegation of my likelihood to become a non-performer. No such allegation. Not on affidavit. Orally may have been loosely said. But if your lordships are ignoring what is said orally, then your lordships may take it. There is nothing on affidavit to say that I had a likelihood also that I will not be able to go through these 29 years and not perform this contract at this rate. That's no such.
No, those submissions are only in the context of
So now I'll
limitation.
come to that context. So, Lord, that is that. Once I get that part of that apart, then, Lord, the next time which the learned ASG made was that some factual inquiry of some Raju and some PV Raju, etc., and third name, and all 3 are the same. That is only an argument to prejudice, because when you sign, my lord, you may sign sometimes in short. Your DIN may be full name, and in your stamp may be a smaller name. But there is not a whisper in the allegation that by using these 3 names, there was any element to misguide them that we are 3 different people. No such element. Because wherever I have signed as Lord, this person, whoever has signed as director of this company or an executive director of that company. His names may have been shown differently, but there is nothing. I'll just read that paragraph because it's a little important. Because it is only to prejudice that a person has 3 names. 3 names is not matter as if there is 3 names. Somebody may say, my father used to write SP Singh. He is Suresh Pratap Singh. Sometimes used to cite Suresh Pratap. Sometimes we simply cite SP Singh. The fact that he writes Suresh Pratap Singh or SP Singh will not make as if he's trying to confuse. His name may have been, he may write Suresh Singh, Suresh P. Singh, or he may say Suresh Pratap Singh, or he may write SP Singh. My name, unfortunately, doesn't have that much of variation. My name is only 2. So it's either V Singh or Vikas Singh. My father could have 3. Similarly, this person also has used this name in this land, and there is no allegation that by using these different names, there was an attempt to conceal the identity. So using 3 names per se is neither here nor there. I don't know why it was argued also. I really don't know why. I'll just show that paragraph. Then, my lord, the argument of malafide, that there are 12 people in the committee.
No, whether so far this malafide aspect is concerned, the main question is can you sustain your allegation of malafide
I'm answering
in the-
that.
in the absence
I-
of
I-
any factual allegation against an individual who is not a party?
I'm unconscious of that. So there are two concepts, Lord and your Lordship would be aware, that there is a malice in facts, and there is a malice in law.
Right.
When there is a malice in law, then I don't need to know who has done what.
You are right.
I know. So this is a case of malice in law. I just want to place two judgments on malice in law.
So
Just a-
malice, in fact, we should exclude.
No, there is no malice in fact, because obviously I don't know who has done, who's behind me, who has made the phone call, who said by in dono ko nikalo. I don't know. How can I not say that? I don't want to get into that inquiry, which I don't have any facts on. So
Yes.
just see these two judgments, not on malice and law. Two 2012 4 SCC 407. 2012 4 SCC 407.
Yes.
No, 2012 4 SCC. 4 SCC.
Yes.
And straight away, if your Lordship would come at page 431 to paragraph 47. Our case is of malice in law, not of malice in facts. This court has consistently held that the state is under an obligation to act fairly without ill will or malice in fact or in law. Where malice is attributed to the state, it can never be a case of
You
personal
are
ill
reading
will.
which paragraph?
I'm so sorry, Lord. Paragraph 47 at page 431. I'm so sorry.
Just. Yes. Yes.
This court has consistently held that the state is under an obligation to act fairly without ill will or malice in fact or in law. Where malice is attributed to state, it can never be a case of personal ill will or spite on the part of the state. Legal malice or malice in law means something done without lawful excuse. It's a deliberate act in disregard to the rights of the others. It's an act which is taken with the oblique or indirect object. It is an act done wrongfully and willfully without reasonable or probable cause, and not necessarily an act done from ill feeling and spite. Malified exercise of power does not imply moral turpitude. It means exercise of statutory power for the purposes foreign to those for which it is in law intended. It means conscious violation of the law to prejudice of another, a depraved inclination on the part of the authority to disregard the rights of others, where intent is manifested by its injurious acts. Passing an order for unauthorized purpose constitutes malice in law. And then these are other judgments, Lord, which are referred to.
Yes.
Then, Lord, if your Lordship will again see 2023 SCC, page 86. Volume 3 SCC, page 2020, volume 3 SCC, page 86.
Yes.
The act of transfer can be unfair labor practice in the transfer.
Oh, which paragraph?
I'm so sorry, Lord. Paragraph 16. Paragraphs. I'm so sorry. At page 93, bottom.
Yes.
The act of transfer can be unfair labor practice if the transfer is actuated by malafide. The allegation of malafide have two facets. One, malice in law, and the other, malice in fact. The challenge to the transfer is based upon malice in fact, as it is an action taken by the employer on account of two officers present in conference. In the judgment of State of Bihar, this court held that malafide means want of good faith, personal bias, grudge, oblique, or improper motive or ulterior purpose. The plea of malafides involved two questions, namely whether there is a personal bias or an oblique a motive and whether the administrative action is contrary to the objects, requirements, and conditions of a valid exercise of administrative power. As far as the second aspect is concerned, there is a power of transfer vested in the employer in terms of letter of appointment. Even in terms of the provisions of the Act, the transfer by itself cannot be said to be an act of unfair labor practice unless it is actuated by malefit. Therefore, to sustain the plea of malefits, there has to be an element of personal bias or an oblique motive. This court held as under. Mala fide means want of good faith, personal bias, grudge, oblique or improper motive or ulterior motive. Lordship has skipped these two. These are on malice on fact. Paragraph 59 of this same quoted judgment. Malice in law could be inferred from doing of wrongful act intentionally
Which
without any
paragraph?
just. I'm sorry, same page, not paragraph 59, quoted 59.
Oh, quoted.
Malice in law
Yes.
could be inferred from doing of wrongful act intentionally without any just cause or accuse, or without there being any reasonable relation to the purpose of the exercise of statutory power. Malice in law is not established from the omission to consider some documents said to be relevant to the accused. Equally, reporting the commission of crime to the station house officer cannot be held to be a colorable exercise of power with bad faith or fraud on power. It may be honest and bona fide exercise of power. There are no grounds made out or shown to us that the first information report was not lodged in good faith. In Bhajan Lal is an authority for the proposition that exists so and so. Then
Yes.
Paragraph 18. In a judgment of HMT, quoting from an earlier judgment of this court in State of AP versus Govardhan Pitti, it has been held that legal malice or malice in law means something done without lawful excuse. It is an act done wrongfully and willfully without reasonable or probable cause, and not necessarily an act done from ill feeling and spite. This court held as under. And if your lordship will then see, this is all malice in law and malice in fact discussed. So all these judgments are basically elaborating on that. So just to cut this, point is basically only this much, that if something is done which is not for the rightful exercise of the power which is vested in you, then it is malice in law. And our case is malice in law.
Yes.
Now, Lord, the other cases which I want to show are the ones relied upon by the ASG and also relied upon by my friend. So he cites some judgments which opine to the effect that even if the state has acted has taken a decision which is not correct, judicial review still will not matter. That's the long and short of the judgments. Now, there are two lines of judgments on this. One, like Justice Bela Trivedi, or Lord, the other ones that I'm relying upon, say that no, if it is wrong, it has to be struck down. So when they say if a person's civil right has been affected, so if I'm a tenderer, my Article 14 has been affected, then tendering authority can't say that whatever I have done is to be accepted, notwithstanding the violation of Article 14. So that line is consistent. That if 14 violation happens, then the tenderer has definitely acted with malice in law, even if there is no malice in fact, and there is a right for the tenderer who has been not harmed or who has been wrongly rejected to get redress from court. And in Bela Trivedi's latest judgment, she says, even if the new person has started working, is of no consequence. If the tender has to go, this person has to be reinstated in place of the other person. So those are those line of judgment, which I am already relying upon. I have also placed some of them. Now let us deal with the other line of judgment, because there is some kind of an apparent conflict that one says you can look into it, the other says you can't look into it. So your lordship have to see why, under what circumstances the court has taken that view. Why the court has not consistently held that in every case court should intervene in judicial review. What is the distinguishing feature of these cases? That the court said that this is not a case where court should intervene. Now let us examine one by one. Let's go to Uflex first, which is relied upon by my friend today, which is not the judgment of Justice Call. Uflex का पैरा मार्क किया है?
Uflex has a wonderful opening paragraph.
First eight paragraphs are very wonderful. नहीं, इसका वो पैरा मार्क किया जो factually सब
Malice
दिया,
given by
it was specialized.
Kumar.
Not here, the reasoning. Tell you, then let me go to the other one first till you look into that. I'm sorry, Lord, Your Lordship, but just give me 2 minutes time for that para is not marked. It was, we discussed yesterday, but not marked. In the meantime, could Your Lordships come to this judgment? AFCON is very heavily relied upon by my friend, Lord, the learned ASG. Just have a look at AFCON.
Yes.
Just find out in where justice Paul says that things are very sensitive matters. But Paul says that the matters of liquor supply, etc. In AFCON, just see Lord paragraph 9. Sorry, I'm sorry. See paragraph 6 first, which is the High Court order.
Yeah.
Before I start reading, can I just give your lordships just a 1-minute introduction on this? So there was a metro rail tender where you had to experience of doing metro rail and also doing a viaduct in a metro rail. There was one lord tenderer who had intercity high-speed rail experience of China. So he said that I have done as many kilometers as you want of a high-speed train, and accordingly, why that should not also a viaduct? So why should that not be counted for metro rail? High Court found favor with this argument and said that yes, he has been wrongly been disqualified, and that is how the matter came to Supreme Court. So just see paragraph 6, the High Court finding first.
Yes.
The civil construction work, the quoted portion block. The civil construction work completed by the petitioner in terms of clause 4.2a was for the intercity high-speed railway project in China. And in the said contract, the petitioner had completed viaduct of 7.284 kilometer length. The petitioner had admittedly constructed a viaduct of not less than 5 kilometers, because that was the requirement, for the prestigious Pearl River Delta intercity high-speed railway project in China. We find on a reading of the tender conditions, and particularly 4.2a thereof, that a contractor or a joint venture company is required to have the experience in metro civil construction work and of completing a viaduct having a length of not less than 5 kilometers. We do not appreciate the submission on behalf of the respondent. Since the petitioner has constructed the viaduct for high-speed railway project, the petitioner would not have the experience of constructing a viaduct for a metro. It is not disputed by the respondent that metro would be in a railway or an underground railway. If that be so, we fail to fathom as to why the technical bit of the petitioner was disqualified, though the petitioner has constructed a viaduct for Pearl River Delta intercity high-speed railway project in China of the length of 7.284. In our view, the petitioner has the experience of constructing viaduct for not less than 5 kilometers and length of metro rail construction work contract, and has also received more than INR so-and-so for satisfactory completing the said contract. The distinction sought to be made by the respondent between construction of viaduct for intercity and construction of viaduct for the metro rail is illusory and not real. This is the High Court finding. Now please see what Supreme Court says in paragraph 9, and very rightly so. It is submitted before us. It is submitted before us that an intercity rail is completely different from a metro rail. Intercity rail is between two cities, and the trains are usually high-speed trains. A metro rail is intra-city. It has dedicated right-of-way. Normally, it does not have a high-speed. Frequency of trains is much greater than that of intercity trains. A metro rail may extend in some cases to a suburb or of a metropolitan city, but essentially remains an intra-city project. There is therefore a qualitative difference between intercity rail and metro rail. By itself, this indicates a qualitative difference in the railway project, that is intercity, and a railway project that is intracity, and the construction of a viaduct for a railway project that is intercity and a railway project that is intracity. So this is the basis. The fact that GY had made construction in a metropolitan city or in a metropolitan area during the execution of Pearl so-and-so does not make the project an intracity. It continues to be an intercity railway project. However, it is not necessary for us to delve into these issues or even adjudicate on them. And then the court says that this is a technical issue.
No, Mr. Singh, see, this is very important. The ratio of this decision lies in the last sentence of paragraph 10, read with 13. Paragraph 13. The paragraph, in the paragraph 9, the submissions are recorded. In paragraph 10, some analysis is short and then say, however, it is not necessary for us to delve into these issues or even adjudicate on them.
That's right.
Why? Come to paragraph 13.
In other words, I'm coming to that. So just let me explain that what I'm trying to say now. So what the Supreme Court says is that whether an intercity or an intracity is to be, so there is no such issue here. Firstly, let me put it like this. There is no issue on whether the work that I have done is not similar work to this. There is no such issue. I am otherwise technically qualified. I don't make it only because of conflict of interest. What the Supreme Court is saying is that, so supposing, let me put this in my case, supposing the work that I had done as an MDO, supposing, had been for an area which had rocks, and which will be the next case which they have relied upon. Unfortunately, I had the privilege not to argue that in Supreme Court. I have done a rock cutting, which is a very different rock than what is existing here. The rock is much harder. Here the rock is much softer, or vice versa. And I want that experience to be counted. Tonnage is matching. I have done the tonnage. And if the court were to say, no, that rock cutting should be counted here also, then your lordships are getting into an area which is prohibited, which the Supreme Court says. What the High Court did was, High Court did not accept the argument of Metro Rail that intercity and intracity are completely different ball games. You can't count that experience for this. So when the High Court said that no, this has to be taken as same experience, Supreme Court says, sorry, we can't get into this. But here there is no such issue of not getting into experience. There is no experience issue here.
The Supreme Court's reasoning is different.
No, so that is what I'm saying. So why the reasoning, why it is like this? Reasoning is on the facts of that. That is how I'm trying. Your lordships are now dealing with cases where Article 14 violation, Supreme Court says has to be set aside. So your lordships are dealing with some cases where Supreme Court says court has limited jurisdiction. So your lordships have to reconcile that why Supreme Court in some cases is saying that you don't have jurisdiction, you should not look into it at all, whatever that. So if the tender authority, whatever they do is correct, then your lordship should also stay at home. We should also stay at home. Because you're also not required. We're also not required. Ultimately, whatever tender authority will do is correct. So if there is no judicial review, then neither your lordships have any role nor we have any role. But if there is judicial review, Supreme Court says consistently there is judicial review. But under what circumstances? Judicial review where 14 is violated. Judicial review where very unreasonableness. Judicial review where arbitrariness. So whenever these are there, judicial review is permissible. In some cases, Supreme Court says no, courts are not right in exercising judicial review. There has to be some law, you have to find what is the common ground. Why in some cases Supreme Court is saying, no, this is beyond our jurisdiction, beyond our pale, we will not get to it. The difference is here. If the High Court gets into technicality of the bidder, the technical parameters of the bidder, that is barred. That is barred. That is barred. Not that High Court can't look into it. This judgment doesn't say that even if there is a 14 violation, still every judgment which is relied upon by them, every judgment has a paragraph which says that if there is arbitrariness, courts will definitely, they have a right to interfere. But every judgment which has been relied upon by them has a distinguishing feature of facts. That the facts are such that really the High Court went into a technical issue which the High Court was not competent to look into. And the technical issue here was this. And I'll show this in every judgment. So the technical issue here was that you are comparing intercity with intracity. Metro Rail says that I will not consider intercity for intracity because here trains are much slower. They stop every now and then. That the frequency is much higher. There you just have a one line which comes zoom and then it goes and stops. So the nature of work is very different. If the metro rail, which is the employer, it says that I don't want to compare intercity with intracity, High Court has no jurisdiction to do that. That is the ratio of this judgment. And the Supreme Court says that, yes, if there is a technical issue involved, sorry, this is beyond the pale of a writ jurisdiction. That's the distinction I'm wanting to make. Now, let's see the next case, which is Monte Carlo.
Please.
Which is Lord 2016-15 SCC 272.
What is that?
Monte Carlo, Lord. Monte Carlo Limited
Yes.
versus NTPC. This was cited yesterday
Yes,
by
proceed.
learned friend.
Yes.
So, Lord, just see the facts.
Yes.
Here, Lord, I had the privilege to argue this matter for NTPC.
Yes.
Paragraph 11. On the
Yes.
On the basis of the said communication, the respondent formed an opinion that the bid of the appellant was technically non-responsible. The reason for arriving at the said conclusion by the respondent was that the appellant did not have the necessary experience of drilling for blasting purposes. They were saying that even if I don't have drilling for blasting purposes, I still should be considered qualified. As the appellant has regarded as technically non-responsible, it invoked the jurisdiction of the High Court, challenging the said determination made by the respondent. It was extended to the High Court that tender documents that contained QR was for the experience of a bidder in only drilling, excavating and hauling, etc., and not blasting or drilling for blasting purposes. It was further urged that the scope of work for Dulanga mines projects which have been taken into consideration by the respondent in evaluating the technical proposal of the petitioner as being non-responsive has been wrongly understood. The stand of NTPC before the High Court was that the assessment by the technical committee was absolutely justified and the writ petitioner therein did not meet the QR and therefore was treated as non-responsive. So I had the privilege not to even argue in the High Court and argue here. Then, Lord, please see paragraph 18.
Yes. Yes.
In fact, have a look at paragraph 14 also. Lord. Paragraph 14.
Yes.
The dispute and the dissension between parties rest on how Chapter 7 QR of the ITB that contains clause 7.2 that deals with technical criteria is to be understood. We are not really concerned with 7.1. The centrality of controversy hinges on the interpretation to be placed on clause 7.12. It is submitted by Mr. Chidambaram, learned senior counsel appearing for the appellant, that the appellant satisfied the condition as postulated in the QR under 7.1 so and so, stipulate that 23 million BCM of aggregate volume of ore burden and or coal lignite from a maximum of 7 open cast mines or coal lines in any year. In clause 7.12 lays down there are at least 11.5 million BCM or composite volume of ore burden and coal from a single open cast mine in any year, out of which only 3 million, at least 3 million tons should be coal lignite. The learned senior counsel would lay emphasis on the documents that the appellant had failed to show that it had operated and produced from single mine 11.5 million BCM of composite volume of overburden and coal lignite from single open cast mine in the year. Mr. Singh, learned so appearing, resisting the said stance would urge that the appellant does not satisfy the condition of drilling as is defined the QR regarding having had the nature of work. In this context, we may usefully take note of the definition of operated. The said term as defined means activities of drilling and excavation. So what was happened, Lord, that drilling was not mentioned in the experience, but the work said it has to be drilling and this thing. Now, Lord, please see thereafter para 18.
Yes.
We have referred to these clauses, which are technical, but they are fundamental to understand the QR. They clearly demonstrate that drilling is imperative. Mr. Chidambaram, learned senior of the appellant, would argue that all the conviction at his command that the appellant is engaged in drilling in lignite and tender requirement was coal lignite. According to learned senior counsel, drilling in lignite would meet the requirement of owner as traveled beyond the postulates of QR to insist on drilling for the purpose of blasting. We have already referred to the certificate issued by the GMDC in favor of the appellant and the documents filed by the appellant. The High Court has considered the documents and opined that documents filed in support of QR are absolutely substantially inadequate. Adverting to the facet of drilling, the writ court has opined that there is a specific use of the words drilling for the purposes of blasting. It is asked by Mr. Chidambaram and Mr. Rawal, learned counsel, that in the absence of definitive prescription, the court cannot add or an attribute or quality component into the qualifying. With this regard, we may usefully refer to the certain authorities and then Lord Sterling Computer, etc. So this is again in the context of a very specialized work being done and an owner interpreting that, look here, I don't want simple drilling. The work has to be done with blasting. Drilling with blasting is an integral part of the work that I want to do. So if you have done merely drilling, High Court or the court is nobody to say that that should be counted. So this judgment also is on this, in this background. And that is why, Lord, this is departing from the normal line that even if there is an Article 14 violation, court still will not interfere. Because these are technical issues. A authority, a tenderer has a right to decide the terms of the tender. He knows what kind of work is to be done. So in this case, Lord, the work that he had done, separate drilling that he had done, or blasting that he had done was of a much inferior quality, Lord, the mineral, which was not so hard as the one which was to be drilled here. So the experience was the machines required for that drilling and this drilling were very different. It had a different Lord, the material component had to be completely different. All that we argued before the High Court, we succeeded. Supreme Court also said. Now, when this judgment is delivered on facts, Supreme Court, of course, goes on and says that, look here, you can't substitute the opinion of the employer. Here, there is no disqualification because of my not being able to do technically this job. Here is only conflict of interest. If it is only conflict of interest, and if I can satisfy Lord that this conflict of interest is just a bogey to somehow keep me out of the process, two of us out of the process, then your Lordship will say that this is a violation of Article 14. If there had been any interpretation by your Lordships to the terms of the tender, the conflict of interest is a legal interpretation. But if some technicality in the tender was involved, which required your Lordships to go into the technical aspects of the work that I am supposed to do,
yes,
then these judgments will apply. And these judgments will then say that no, writ court or Supreme Court will not substitute its views to the view of the employer, because the employer is the best judge to decide whether a contractor meets the requirement or not. Of course, there also, there have been even cases of those kind, Lord, where courts have even taken the view that if the courts are in a position to appreciate those kind of facts, they have taken the view, yes, this is a wrongful rejection. But there the window is a very narrow window, where courts will get into the merits of the matter. Courts will not get into the merits of the matter normally. It will be, if I may say, in terms of percentage, probably 95% cases of such kind, courts will say, no, we have no expertise to decide whether you had the technical capability to do or not. That is for the employer to decide. And all these paragraphs which are written thereafter are only in context of this, that this is a technical bid which has been not rejected. Here there is no technical. Here there is a consistent practice. Here there is a subsequent clause which clarifies. A clarificatory clause goes back, Lord. So all this is here. So here there is no issue of Lord. And here there is a saving of revenue to the tune of 6,500 crore. Now, Lord, why Mr. Sethi had said 3,000 crore and how that has become 6,500 crore? Let me just explain that also. I'm not just to Lord, because I'd argued this yesterday. 3,000 crore is the difference in the tender value straight away.
Yes.
But it has an escalation clause. So when you take the escalation, the overall value for 27 years becomes blood. 6,000. That's how blood the 3,000 has changed to 6. It's not blood as if that every day I'm wanting to change the figure. It's just that the calculation has been done for the entire period of the contract now, and that calculation comes to 6,500 crore. Lord, I will only request, Lord, if your Lordship permit me to finish in 5 minutes, because I have a flight at 5:50.
Yes, you can do it. You can.
No, I will not be able to finish. That's my
Oh, you will not be.
My lords, my imagine my position.
In fact, I'll not be able to, because there is a lot of, I want to show, Lord, these are judgments.
When are your flights? Depends on
My
that.
flight is at 5:50, Lord.
All of us minutes. 5:50, that's the
But
only flight.
my baggage is in the car. I can do for another 10 minutes. But I'm going straight from here.
As you wish, in fact.
I can do for another 10 minutes and then.
See, even otherwise, we have to adjourn the matter because of the
That's
affidavit
what I'm
which you have
submitting,
filed.
Lord. That is the problem.
Even this price justification which my friend is saying is put in the due affidavit filed today.
No, but this I had given yesterday.
It's not something which was on affidavit earlier. So anyway, my lord.
But the price it has taken, your price, has the escalation been considered in that, or only for them they have put in the
Only for them it
escalation?
is being considered. Not
I've
for me.
taken escalation. Well, I
them
didn't get
also.
it.
Applies both ways.
There's a limit. So where will I go after escalation and where they will? So I've taken escalation at my rate and
But
escalation at their rate.
My
I've taken
respectful
that.
submission will be that if we are to adhere it on another day, then
Yes.
might as well stop now instead of another
right.
10 minutes, because
Very well. Very
next time
Yeah,
it's
that's
not that my friend will take 10 minutes less. Nobody remembers that later on.
No, Lord, these are important matters. I don't want
but-
your lordships to rush into anything so that anything is left
But,
out.
next, today, an additional affidavit has been filed.
Two additional efforts.
Two additional affidavits have been filed. In which case?
In Lord, the NCC,
In 17
188, 1718.
17188.
188 2020. Copies of which have been served on current counsel representing the opposite parties. Stop.
Yeah,
Opposite parties. Stop. List this matter for further hearing on which date?
Lord,
Lord,
would it be 13th if it is.
Wednesday. Half day.
my lord, I've been just instructed by Mr. ASG. I was assisting him in that matter. But can it be week next? Any day? Would it be 12th?
What are you saying?
My lord,
13th, my lord, is very difficult.
13th.
It's very
could
difficult.
we pray for 12th minutes?
No, my lord, I am requesting if it could be 20th, my lord.
Yeah, my lord, that will be fine.
Not only
That's
thing is looking
28th.
far.
Two,
14th, no.
13th,
14th
14th.
is all right. Let it be
14th is a miscellaneous day in our court,
yes,
Supreme
yes.
Court, so that I have no problem. 15th
I am
is
ready
a
to
holiday.
sacrifice Lord, but
No,
he's
how
got
about
the bid
15th
of
is a
this. He
holiday?
can't.
No,
My
I will
Here,
come.
here.
Let it be 14th.
lords, my lords,
20th.
is 15th holiday for your lord, this honorable court?
15th we have fixed one matter.
No, 15th is
Because-
a holiday, Lord.
15th holiday for us.
15th.
I wonder whether my lords.
It's
Oh,
a holiday here also.
15th is holiday here.
my lord, may I
Yes,
think of 12th
No,
minutes?
Lord, then
It will
could it
be
be
at
21st,
least.
not 20th, Lord? 21st.
My lord, may I just
21st
request
is
that?
21st, Mr.
Let it be 21st, Lord, no problem.
21st.
Like,
21st,
21st is okay.
Thursday.
It will be open for the.
For only concluding.
It is, it will be open for the opposite parties to file, to consider the said additional affidavits and file response so required.
Lord, if your lordships are giving 1 week to be for any rejoinder, so that
We make it clear. Can you do it? If required within 1
But
week.
first, they have to give a actually, my lord, my friend is pointing out their mistake.
So they will.
No, it's not a question of mistake. It's a
So no,
question of
whatever, or practice, they are saying that it is a practice, common practice.
No, so whatever.
I'm sorry, Lord, all these 10 cases are where my friend's client has participated. So he would have all these.
You are saying it is a practice, that's what you are saying that
No,
I
no,
have been
but these are tenders that they
Mr.
participate.
Singh,
Anyway, my lord, so.
speaking for myself, I have this adopted this practice of confining to what is there on record.
No,
So
no, I appreciate
strictly, I don't go. So once that those materials come, that
Please.
that will be.
So
Could
my-
your lordships indicate 1 week and 1 week so that not we.
It will be convenient for this court. Just a minute. It will be convenient for this court to consider rival submissions, to appreciate rival submissions to be made on behalf of the parties on the next day. If the response to the said response bracketed this to the said additional affidavits are filed well in advance.
Deeply obliged, deeply obliged.
Let's maybe pray minutes. It would come like this early in the morning, in the sense, at the first 5 or whatever.
Because why we are saying.
So that all of us could complete.
No, because it's a Thursday, my lord. Since your lordship keep old matters on Thursday, therefore, my lord, we are making that request, my lord.
But you will have to see, contribute to the Odisha bar.
Of course, yes, of course.
Hijack the High Court.
Quite so, my lord.
So Vikas Singh, something should be done for the Bar Association of Odisha High Court. Because
Lord, I have always been, Lord, I've been appearing for the bar and I've also,
Yes.
Lord, taken the initiative. Lord, your lordship will recall when that problem happened, I was representing the bar. And I tried to, Lord, ensure that this.
all of you are flying together.
Yes, ma'am.
Yes, we're all flying to the same flight.
Resolved.
Yes, my lord. Thank you.
Deeply obliged.
Very obliged.
Grateful,
Very
yes.
obliged.
Deep.
Extremely, again, I want to reiterate what Mr. Nataraj,
Thank
your
you,
lordship,
thank
have been extremely kind to all of us.
Very grateful.
Deeply obliged.
Great.
Next Thursday, 4th and Thursday. 3, okay, yes, 3, 4. No, Mr. Mishra said he will. His junior will be there, he will be all right.
Old matters, item number 3.
Maybe nobody will be here.
No, we will not pass any reverse order.
Item 4.
3, my lords.
4, we have.
Yes, ma'am. On next Thursday. Item 5.
You are appearing in which matter?
3,
Three.
3.
3, Mr. Mishra had said that he will leave, Mr.
Will be taken after a week. He is here.
All right. Next Thursday, no?
Next one.
On 14th.
3, 4 next Thursday.
5 also. Yes. Item 6.
Item 6, what I find went from the order sheet, my lord. For the last several days, the opposite party is not coming to the court.
But today we will adjourn.
Yes, your lord.
The matters will come on, all the matters will come on Thursday.
All these old matters,
Next Thursday.
May I call the fresh
Next Thursday.
fresh matters you.
First,
You want to file now?
So, fresh admission matters. Item number 17.
Item 17. I am for the petition council.
old matters have been adjourned to Thursday.
Now the fresh admission, yes.
Fresh admission matters, item number 17.
And council are under the impression that
Yes, because that matter was going on.
we can raise that. Can we raise?
Any urgent matter or no?
That will be in the interest of the government.
All right.
Pardon, my lord.
Tuesday. Wednesday. So Wednesday, ready is or-
Tuesday,
Not
my lord.
twelve. Why not 12? No, I mean, I'm saying maybe urgency.
There's so many things.
Well, when it is- Okay. Oh, okay.
Wednesday. All the, I have to notice matters on 14.
Pardon, my lord. Pardon, my lord. Pardon, my lord.